Welcome to the Fourth Circuit, and we're glad to have argument in our first case, Lavis versus Reverse Mortgage. Mr. Manning, we'll hear from you first.
Thank you. May I remove this first?
Yes, sir.
Speaking? Thank you.
We can all hear better when you do.
May it please the court, my name is Jason Manning on behalf of the appellant Reverse Mortgage Solutions. This case involves the rescission of the appellee Ms. Lavis's reverse mortgage loan under the Truth in Lending Act, and whether she was required to tender the proceeds of the loan she received to be permitted to retain the property free and clear of any interest or the ability of my client, the appellant, RMS, to recover the property. In other words, the appellee asked this court to let her keep the money that she borrowed, the $57,000, and the property free and clear of any lien. The district court's legal errors on appeal here arise from a misinterpretation of the U.S. Supreme Court's decision in Jesenowski, the 2015 case. More specifically, the district court's interpretation is contrary to the plain language of the Truth in Lending Act, Section 1635B, and the rulings of this court, and the rulings of 4 other court of appeals, specifically the 3rd, 6th, 10th, and 11th. The body of law here dictates, first, that tender is required to effectuate rescission of a loan contract, and second, that it is the borrower who is seeking rescission who must file suit and plead an ability and intention to tender. There is no requirement for the lien holder, or lender in this case, to file suit.
Counsel, did I read it correctly in the record that the district court ruled, by my count, 4 times prior to the final ruling that tender was required?
Yes, Your Honor. I believe, by my count, it was 4 before and then again once after trial. So a total of 5 times that tender was required.
Counsel, just for the sake of discussion, assume we agree with you that the failure to respond within 20 days doesn't eliminate the tender requirement. B does say that before tender occurs, the creditor must comply with its obligations. So how does all that work? I mean, to my knowledge, at least from the record, your client hasn't complied with its obligations, including releasing of the security interest. So how do these things kind of work out? If the borrower, for example, is able to show that she could tender, I mean, how do we go from here mechanically if we were to agree with you?
I understand, Your Honor. So the statute allows for the court to change the order of the procedures, and even if it declines to change the order, it cannot obviate the need to actually receive and require the tender of the loan proceeds. So in other words, in this case, there was a notice, not a lawsuit. It did not say anything about rescission. It did not say anything about ability to tender. The case law, and this is from several other courts of appeals, says that the way it works is typically it's a pleading requirement, frankly. They have to actually say we're going to tender. But if they don't, then the court can say, for example, we are going to require tender before we rescind or release the lien. But in this case, the district court declined to switch that order. That's okay as long as you deem it ineffective without tender of the loan proceeds. So in other words, the court has the discretion to do it one way or the other, but cannot get around the requirement that's well established to require the actual rescission to be effectuated upon receipt of the loan proceeds.
So if, taking that a little bit further, I mean, the jury's verdict was in your client's favor.
Yes.
But the district court excluded any evidence related to tender.
Correct.
So I suppose your argument would be that she maybe can't or won't, but we don't really know that for sure from the record. So, is it, would, under your theory, would Lavis be entitled to show the potential ability to tender?
No, Your Honor, I would disagree that the record does show her inability to tender.
How is that?
Specifically, it was stipulated that as of May 31st, 2018, RMS had advanced on her behalf
Right.
taxes in the amount of $493 and insurance premiums in the amount of $3,000 and change for a total of over $3,500. And then, after that, there was a repayment plan, which was
A repayment plan?
yeah, so that she could get caught up on those past due taxes and insurance. That was entered into in April 2015, and it required $56 per month.
Right.
And Ms. Lavis defaulted on that after making one payment. That was part of the record. We were prevented from arguing anything about whether she could tender the $57,000, but the record is clear that she couldn't afford to pay $56 a month.
Okay. Is this in the record? Have, since all this, the litigation has proceeded, taxes and insurance have continued to accrue? Has your client been paying that, or is that how that's
That's
working?
correct, Your Honor. I don't believe it's part of the record past the actual conclusion of the trial, but to this day, my client
And
is
is Ms.
still,
Lavis still occupying the property?
as far as we know.
So let's just assume for purposes of argument that we agree with you and we vacate the district court's opinion. The case is remanded. In your view, what happens then?
Because of the evidence that is part of the record, the court is required under Jesenowski and the Truth in Lending Act and innumerable other cases to enter judgment and reinstate the jury verdict in favor of RMS.
So would there be further proceedings required to establish the tender amount? I mean, particularly if there are amounts due from whenever the plaintiff stopped paying through to whenever the matter's consummated. Wouldn't there have to be some additional fact-finding in that regard?
I believe that to establish the tender amount as of today, we would need to provide the borrower or her counsel what the advanced taxes and insurance through today were. But it's a moot point because she couldn't afford the $56 a month prior to the trial. There was no offer, no
Why do we
intent.
necessarily make that assumption, right? So you say her failure to pay $56 a month suggests an inability to pay. Why wouldn't we just as likely assume from that she just chooses not to, right? Gets free money from you, right? She's been getting free money from you for a long time. Why wouldn't she just keep getting free money, right? She might have all the money in the world, but why pay $56 a month if you don't have to? I'm just as a matter of evidence, I'm not sure why her failure to pay, we should assume inability as opposed to just a choice to keep getting free money from you.
Well, first I would say during the trial she testified that she couldn't afford the $56 as opposed to didn't want to. But second, I think the bigger issue is it's inequitable. I mean, I believe that's what Your Honor is getting at. Why pay something if I don't have to? I understand the logic behind that, but the law precludes her from doing that.
Well, she says not. She says that her theory of the case is you didn't do your obligation, and so you complying with your obligations is a condition precedent to her obligation to tender. So, I mean, y'all disagree on the effect of the law, but under her theory of the law, it's a windfall and a forfeiture effectively for you. So, I mean, I think both these, the questions kind of get to, and I think in your brief, you say you'd like it reversed, but, alternatively, we should condition, some sort of remand on, or condition your, requirement to terminate your security interest on some evidence of either, tendering or establishing that the inability to tender. And it seems like that alternative you asked for gets to the questions that Judge Agee and Judge Richard are talking to, that we need something to kind of tie things up under your theory of the case, it seems.
And I understand your point on that, but I believe the record is established enough on its face to be able to show that, I mean, she never said, I intend to pay. I have the ability to pay. Those are her affirmative pleading obligations, as this court has indicated. I mean, she has the requirement. And
Do you have, just so that I will find it easier, do you know where she testified that she lacked the ability to pay the $56 a month?
not off the top.
That's fine.
But I will look for it.
No, that's totally fine. I've got somebody that can find it.
Okay. So to that point, Your Honor, this court has affirmed rulings of lower courts that dismiss claims due to the failure to plead the ability to tender. I mean, this should have never gotten this far, is our position. And that was the Suggs versus M&T Bank case in the Eastern District of Virginia.
Can I ask a slightly different question, or
Yes.
maybe the same question, frankly? But so the statute provides that the obligor shall tender the property only upon the performance of the creditor's obligations, right? And the creditor's obligations requires maybe two things, right? One is the termination of the security interest, right? This is what we've been talking about.
Yes.
And you indicate, well, yeah, the court can reverse that order based on subsection B. I understand that argument. But why doesn't it also, the creditor's obligation is that they do so within 20 days. So in other words, the time limitation is part of the obligation that you have. And so once you haven't terminated the security interest within 20 days, the game's over. You've lost. Why is that? Why wouldn't we read it that way, as saying you can no longer perform your obligations because you didn't do the termination within 20 days? Why don't I read the statute that way?
So first response is because it's unjust enrichment and it's inequitable. And
Okay,
the
but
fundamental.
what I do is I read statutes, right? And like, if Congress decides to unjustly enrich somebody, right, we might say they do that a lot. We might say they don't do it enough. I don't have a view on that issue, right? My question is, why don't I read the statute that way?
And that's where I'm going next,
Okay.
because we're interpreting the statute in light of the law. And what is the goal of the Truth in Lending Act?
But do
And
you
the
have
goal of
any,
rescission.
all right, so other than like unjust and the goals and the purpose, do you have any reading of the statute itself
Yes.
that you want me to think about?
Yes, so I would point Your Honor to 3 other Court of Appeals cases
Okay.
that discuss this. So there's no requirement to take action within 20 days or waive the right to contest rescission. And the first case is Segrist versus Bank of New York Mellon. That's the 6th Circuit, 744 Fed Apps 932.
Are any of these in your brief?
Yes.
Okay.
Nothing, in the quote, nothing in the language or logic of 1635B requires a lender to file an immediate lawsuit to avoid waiving all defenses. That was the 6th Circuit.
Are there any that are published? Maybe let's start with that question. Are they all
Yes.
unpublished?
Yes, the next one is Pohl versus U.S. Bank. This is the 10th Circuit, 859 F. 3rd, 1226, 2017, rejecting the argument that notice of rescission becomes incontestable if a creditor fails to bring a lawsuit challenging it. Third, Barrel.
Why is that? That doesn't address my. Anyway, I'll look at it. What? Give me the last one.
The logic behind that one, Your Honor, just to unpack it briefly, is the argument was the same. It's incontestable. You didn't do something within 20 days. And the court ruled, no, you have a duty as the borrower claimant to file a lawsuit, not the lien holder to do something else.
But counsel, I mean, you know, there are cases on both sides of the issue. I mean, there's a Ninth Circuit case that supports Lavis. I mean, I think Judge Richard's saying, yeah, we get the equitable arguments, we get those things, but where in the statute? And what I thought you were going to say is the last sentence of 1635B, which if the 20-day obligation was a showstopper, what's the point of the last sentence that lets the court do other things? Or I thought you might look at the civil liability section of the Truth in Lending Act, which sets forth a whole bunch of relief and never says that one form of relief is that the creditor forfeits, any amount borrowed. Those are statutes, those are part of the statutes as opposed to equitable arguments, aren't they?
They are, and I was just highlighting how other courts have looked at it. But to your point, the conclusion in the Truth in Lending Act itself says that ownership of the property doesn't vest in a borrower until a tender offer is made, and that's straight from the Truth in Lending Act.
Where is that provision?
It's in 1635B, and I could find the actual.
That's all right if it's in 16.
All right, counsel, thank you very much. You're a little over time, so we'll
Thank you.
come back to you in rebuttal. And I have a question for both counsel, so if you'll be prepared to answer this when you get back up. So Ms. Brown, we'll hear from you, and the question that I have regards the bankruptcy court's ruling. As I understand it, both parties agree that where the district court overturned the jury's verdict on Lavis's claim for failure to honor rescission, that is moot.
Yes, Your Honor.
Does the bankruptcy court's order affect any of the other issues in this case, in your view?
Yes, good morning, Your Honor. Ms. Lavis had raised or challenged standing for RMS to obtain affirmative or monetary relief from Ms. Lavis, and we continue to maintain that that is inappropriate following the bankruptcy, that RMS does not have appropriate standing under Article 3 to pursue affirmative relief from Ms. Lavis.
All right. Go ahead.
Good morning, and may it please the court. My name is Sarah Brown, and I represent Teresa Lavis, appellee and plaintiff below. The Truth in Lending Act is a powerful statute designed to benefit consumers, and statutory rescission under the Truth in Lending Act differs from the common law and is expressly more powerful. There is a straightforward statutory regime, as Justice Scalia called it in Jesenowski, that sets out in detail the process to obtain statutory rescission. And it does not, as the Supreme Court in Jesenowski clearly ruled, require tender.
Well, that was a statute of limitations case.
It was, Your Honor.
So how do you get to tender?
The Supreme Court in Jesenowski found, in order to answer that statute of limitations question, that the rescission is effective upon the notice that the borrower is exercising his or her right to rescind.
It's true at one point that that's what the court says, no doubt the rescission is effected when the borrower notifies the creditor. But then on the next page, twice, it says written notice to a lender in order to exercise his right to rescind. And in the next paragraph, the borrower must do in order to exercise his right to rescind. So isn't there a difference between exercising the right to rescind and effecting rescission?
Your Honor, there are steps that remain under the statute in order to complete the rescission, including release of the lien of the deed of trust, release of that security instrument. However, the statute itself provides as a matter of law that once that notice is issued, by operation of law, that security interest becomes void.
So your view is that tell me if I'm reading this incorrectly, that within 20 days, the creditor is required to bring some sort of action if it wishes to contest the notice of rescission.
Yes, Your Honor, or it may choose to begin the process of releasing its security interest.
Is that, that's a pretty significant sea change in lending, and I would think in that circumstance that there would be some significant legislative history to that effect, but I don't see that either side has cited any, nor am I aware of it in any other case that's considered these issues. It just strikes me as odd that Congress would make such an enormous change without some discussion of it.
There is finding of the congressional purpose in the Truth in Lending Act, as well as the amendments that added that final sentence in Section B that the court has already looked at. The procedures prescribed may,
So what does it say about requiring the lender to act within the 20 days or losing their security interest?
I'm not aware of specific congressional testimony, but I do have judicial findings that it is the powerful purpose of that statutory rescission to ensure that lenders provide the required material disclosures. As the district court noted in this case, RMS would not have been in the position of facing a rescission notice had it provided the proper material disclosures at the time the borrower entered the transaction.
So
that is the purpose.
For sure, and I don't think there is a big contest, if any, that the notice of the right to rescind, I think, which is the issue here, wasn't given at the time of the closing.
That's
But-
correct.
But you know, just following up, I mean, it's a remarkable remedy if, in response to an admitted failure, which is important, you know, a security interest, which could be, you know, tens of thousands or hundreds of thousands of dollars, just vanishes. And the where in the, I mean, I get I get the reading of 1635B that says, you know, within 20 days the creditor must act, and the part that says the tender, you know, takes place after the creditor fulfills its obligations. But I didn't see anything in the statute that articulated the relief that your interpretation of that would provide. Did I miss it?
I think the closest, Your Honor, is in subsection G of 1635,
Okay.
which talks about the additional relief. If a court finds that a creditor, like RMS, violated this section by failing to honor the notice of rescission, in addition to rescission, the court may award relief under section 1640, which would be the violations for failure to honor the notice of rescission. So right in the statute, it's
But
contemplated.
you've already agreed that's out.
Affirmative relief, yes, Your Honor. But the court may, as it did here,
So
award.
how does that affirmative relief affect the rescission decision?
Your Honor, it may not. The court first looks at the statute. RMS is not entitled to statutory rescission by failing to act within 20 days to either release its interest or invoke judicial procedures to make alternative arrangements for rescission, release of the deed of trust, and tender. The court retains in equity its ability to craft an appropriate remedy, which could include requiring tender, or there could be another basis for a creditor to receive tender. In this case, RMS did nothing. It did not act within 20 days to release its security interest.
Can you go back again? I'm sorry, I'm trying to follow, because I think what you said is important, but I'm not totally sure. Judge Quattlebaum asked you the question of what indication is there that the 20-day requirement, if not met, would terminate their interest, and you pointed us to G. Is that, and so your take is that authority isn't mandated by the statute, but instead comes from G and the equitable authority of the court.
I apologize. I may have misunderstood the question. Section B itself expressly in the first sentence states that by issuing notice, the borrower issuing notice of her intent to rescind, by operation of law, the security interest becomes void. The Supreme Court is clear about that. The statute is clear about that. If the creditor, in response to receiving that notice, takes certain steps, they may then receive tender. Tender is a condition precedent upon the creditor within 20 days, either invoking the judicial procedure. And in this case, RMS may have said, look, it's been 3 years and she can't pay her taxes. We got this notice. No way is she going to tender if I go to the courthouse and release. I better file an action that says I'm not going to release until I get bank statements, until she provides a proffer of evidence to the court. RMS has available options to it to receive tender.
If I'm understanding your answer correctly, you're saying within the same statutory provision, the security interest is voided, but somehow the creditor, if they act within 20 days, can undo the voiding?
No, Your Honor, they may preserve their right to tender by acting within 20 days to receive the loan proceeds in exchange for it releasing.
Right, the statute doesn't seem to say that exactly the way you word it, though, does it?
The statute provides a clear process and it flows one step to the next. So it clearly provides that the security interest is void upon issuance of the right that the borrower is exercising rescission. Within 20 days, the creditor shall return and shall take steps to reflect the termination of security interest. And then upon the performance of the creditor's obligation, the obligor shall tender the property. You don't get the next step and the next step until you've satisfied the conditions precedent.
So how would you distinguish two prior decisions of ours, Gilbert versus residential funding and American Mortgage Network versus Sheldon? Because in Gilbert, we said to complete rescission and void the contract, either the creditor must acknowledge that the right of rescission is available and the parties unwind amongst themselves, or the borrower must file a lawsuit so that the court may enforce the right to rescind. And similarly, in Shelton, we said that where the borrower intends to rescind the contract but is unable to tender the proceeds, the remedy of unconditional rescission is inappropriate.
Your Honor, both the Shelton case and the Gilbert case are distinguishable to the extent that this court would strictly read the requirement that under the Shelton case, this court found unilateral notification does not automatically void. I believe that to be in conflict with the Supreme Court's clear ruling in Jesenowski. However, in Shelton, we know that—
So you're relying on that one phrase from Jesenowski.
As well as the statutory language, Your Honor, yes. Additionally, in the Shelton case, the creditor acknowledged receipt of the notice of rescission within 20 days and filed suit itself to modify the procedures. Factually very distinguishable from RMS's total failure in this case to respond within 20 days or invoke the court's jurisdiction to modify the procedure.
Well, obviously, we're all a little confused by the language in Jesenowski, but I have difficulty making the two different phrases in Jesenowski come together. The first one that you rely on, but then twice at the end of the opinion, as I noted earlier, the court talks about affecting the right to rescind. And those two phrases seem to be in conflict.
I read Jesenowski, Your Honor, as saying that there are steps that may change depending on the creditor's response to the borrower's notice that she's exercising her right to rescind. If a creditor responds by invoking court's jurisdiction to say, in some of the cases cited, the Truth in Lending Act doesn't apply. The creditor comes back and says, either it's been more than 3 years, we have proof of providing disclosures and therefore this period's limited to 3 days, or some other justification as to why the Truth in Lending Act may not apply to the loan. And so I believe the language in Jesenowski is leaving open the possibility that a creditor may receive this notice and challenge the rescission and therefore invoke the court's jurisdiction, or otherwise challenge that this was a case where rescission could apply. In this case, the record is clear and the parties have stipulated, it's in the record at page 2386, the party stipulations, that this loan is subject to the Truth in Lending Act, that RMS had no documents showing it provided the borrower with her proper disclosures, and that her notice exercising her right to rescind was timely received within 3 years. And again, there's no dispute that RMS received that notice. Therefore, following the clear language of the statute and the Supreme Court's opinion in Jesenowski, RMS did not get to the tender stage. And there's nothing in the court's, the statute.
There's nothing in Jesenowski that says you've got to file within 20 days if you're the creditor. I mean, that just wasn't before the court.
I agree, Your Honor, but there is language in Jesenowski discussing potential remedies, and I'm looking at page 263 in the Jesenowski opinion, looking at that section 1635G for a remedy. Section 1635G makes clear that a court may not only award rescission and thereby relieve the borrower of his financial obligation to the lender, but may also grant the remedies afforded under 1640. So Jesenowski did contemplate what may flow from its finding that that rescission is complete upon the issuance of the notice from the borrower.
All right, so can I ask, obviously a hypothetical, and I mean it to be hypothetical, so don't tell me this in this case, right? So if I've got a creditor and a notice is filed, and it's a good notice, everything fits and does whatever, they get it, and on day 25, they take the actions that they're required to take in order to terminate the security interest. And then at that point, the borrower says, you didn't do it within 20 days, and so I'm not giving you anything, I'm not doing anything. Is that correct? Is it a matter of law? Are we finished then?
No, Your Honor.
Okay, tell me why not.
The court still has the ability in equity to fashion a remedy.
And that's in G. And you're sort of looking to G for that idea.
Yes, Your Honor.
And so if then there's a suit filed by the creditor that says, no, like, we've done that, give us the tender, then the court has the discretion one way or the other to say yay or nay, depending on, what it might think of the equities.
Exactly, Your Honor. And in this case, the district court may have chosen to award tender. She, throughout the case, said she would look at the issue of tender. She did not use it, the issue of tender, as a part of the affirmative case in chief to establish whether Ms. Lavis had successfully exercised her right to rescind, but always intended to look at what would be the appropriate remedy and would she be required to tender. In the Shelton case, this court found that the borrower was acting not in good faith, had always set forth that he was never going to tender. The evidence from Ms. Lavis in this case, which is in the record at page 1110, demonstrates that she intended to tender, and she talked about going to refinance to obtain financing from United Bank, where she had banked before in Beckley, West Virginia, to provide this amount. It's in fact RMS's conduct, its failure to follow the statute, that prevented her from being able to tender. Had RMS released its security interest, Ms. Lavis would have been able to put her property up as collateral for a refinancing in order to tender. It's RMS's own conduct that prevented her from being able to do so.
Help me understand that. That just doesn't seem to comport with how lenders operate. I mean, folks go to the bank every day with a lien on their property, and if they want to refinance or they want to obtain some other equity loan, they just produce a letter from that existing creditor that they're going to release the lien upon tender of proceeds. I mean, that just... your answer doesn't seem like it's a real-world answer.
Your Honor, the difference would be that in this case, the amount of tender necessary, Ms. Lavis may not have been able to obtain without this first security interest being released. And courts routinely find that the appropriate, including this court in Shelton, the appropriate or best practice when tender is required is to provide a period of time after the lien is released in order for a borrower to be able to tender.
So, counsel, let me follow up on, I appreciate your reading of the statute kind of first sentence by second sentence, and I might disagree that it's completely clear because there's some things that aren't specified. For example, it doesn't say specifically what happens if the creditor doesn't fulfill within 20 days. I appreciate your argument about how you interpret that. But that argument's kind of a mechanical go step one, step two, sort of way of looking at it. If that's the way it works, that mechanically, the last sentence of B seems to be kind of weird or out of place because it says, here's a step, but the court can alter this if it wants to. So does that last sentence undermine the kind of way you're reading the statute that, all right, it's over 20 days, you didn't sue, you didn't release your security interest, you're out of luck, period. It just seems like within that last sentence, it doesn't make sense if it's that mechanical.
Your Honor, if the creditor does not want or wants to protect its interest by not following the step-by-step within 20 days, it has the duty to look to the court to provide alternative procedures. I think the best practice would be to do that within 20 days. I agree that there's not a separate statute of limitations. Courts have routinely found, the Ninth Circuit in the Patolo case in 2015 that followed Jesenowski said that upon receiving that notice, lenders do continue to have options. They can begin the process of releasing its obligation, or it can seek judicial intervention. In this case, because RMS failed to act completely within 20 days or at all. There was another matter where the court, in the Ironata case in the Seventh Circuit, the defendant moved the court in response to summary judgment to set reasonable rescission procedures under 1635B. Did so well beyond the 20 days, but the court in that case still then ordered
Aren't they
tender.
kind of doing it aren't they doing it in this suit? Your client has initiated the action. Counts 7 and 8 are both for rescission, and they're, in this suit at least, doing something similar to what was done in the Seventh Circuit case. Is that not right? They're raising the issue, seeking the court's involvement on requiring intervention in response to your claim. What's different about those?
RMS has failed to so directly invoke the court in that way, Your Honor, in this case. All they did was affirmatively plead as affirmative defenses, set off and recoupment, and of course there were no monetary damages to Ms. Lavis to be offset or recouped. RMS took no other action to involve the courts specific to set out alternative procedures.
So, and that may help me out, and you know the record better than me, and obviously, but I thought they sought to introduce into evidence information or evidence about inability to tender, and the district court excluded that.
That's right.
So how is that not? Maybe there's not a counterclaim, and maybe that's your point. You don't get to do it unless you assert a actual claim or actual affirmative defense. But it seems like it was raised in some fashion, maybe in your mind not formally enough.
RMS always, Your Honor, sought tender, but sought it as a part of what it saw Ms. Lavis's affirmative burdens to prove in order to receive rescission. And that's clearly counter to the statute as well as to the law in Jesenowski. Therefore, it did not do enough to retain its rights to tender.
I understand.
Thank you very much. Mr. Manning, you've got some time left in rebuttal.
Thank you, Your Honor. I just wanted to address, Judge Richardson, you were asking in the record, where I found an example. It's Joint Appendix page 2503 and 2504 regarding the inability, not lack of desire, not lack of effort, the inability to pay $56 a month. And what we're dealing with is $57,000. I wanted to touch briefly on the failure to honor rescission because I understand that was raised. There's a separate statutory penalty for that issue. Obviously, it's moot because it's a monetary claim and the bankruptcy bars it. But there's also a case law that says that ruling should be reversed because there isn't a failure to honor rescission if there's inability to tender. And the case for that is from the Southern District of West Virginia, Lenhart versus Bank of America, also cited in our brief. And it's just an example.
I'm not sure I understand what you're saying. This is an issue that's mooted by the bankruptcy court's order?
Because there was a third ground for appeal that we were seeking to overturn failure to honor rescission finding under 1635G. And although there can be no monetary relief, that ruling should also be reversed because, again, it's contingent on a finding that there's ability to tender. There can be no failure to honor rescission if the borrower hasn't proven her affirmative pleading duty of ability to tender. And then the other point I wanted to identify was when your honors are interpreting the statute and it is either confusing or ambiguous, it can't be read to work a profound injustice. And what we're talking about here is stripping liens. We're stripping mortgages because of a failure to respond to a notice that was sent by an attorney and said, don't talk to this person, right? He's representing the borrower. And there's no statement of intent or ability to rescind, meaning tender the proceeds. They don't even ask for rescission in the notice. So if we're going to talk about the notice being some kind of formulaic requirement that triggers an obligation of a creditor to step in and do something, there should be a requirement as to what has to be in that notice. Otherwise, it's a game of gotcha. We're talking about something that is removing an undisputed lien, and in this case, an FHA HUD-insured lien. And it can't just go away into the ether because there's not a response. Instead, the courts have routinely and consistently held.
I hear opposing counsel to say that the statute is clear that once the letter goes out, we'll assume it's effective to show a right to rescind, that does void the security interest as a matter of law.
And I disagree with that interpretation, but let me just, again, for hypothetical sake, let's say that she's right. It cannot be read that that is an unconditional voiding. It's not effectuated until there's actually a tender. And that's where the statement in 1635B comes in, where the court can exercise an ordering of what these steps, the order the steps take place in. Okay, it's deemed void as long as you can pay tender. But if you can't pay tender, it is not an effectuated voiding of a lien. You can't just strip a lien because of a notice. You have to, the whole intent of this is to put the parties back in the status quo ante. That wasn't done here. The record is clear. She couldn't do it here. She never said she was going to do it. And despite the court repeatedly holding it was going to be required, after the jury came back in favor of RMS, it was a complete about-face. And it's contrary to the overwhelming body of law that says you must prove ability to tender as a pleading. You must prove it to avoid summary judgment as a matter of law. And then at the conclusion, it's not effectuated rescission unless you actually pay the proceeds that are owed.
Counsel, you said a second ago, and I don't remember this from my review, that the notice that came from Ms. Lavis, and I've been saying Ms. Lavis, so I apologize if I mispronounced that earlier, but didn't mention anything about rescission. But I thought that in May of 16, the letter to your client did say they were rescinding the loan. Are you saying that the letter, there was never a letter putting you on notice of the claim of rescission?
May 12th, 2016,
You're right.
Lavis sent a letter directly to RMS purporting to rescind the loan.
Okay. I thought you just said a second ago that the notice didn't say anything about rescission.
I meant to say about tender. So if I said that, I apologize.
Okay.
I've got my note here, and I'll continue just for clarity. It wasn't served on RMS. It was mailed, so not effective process of service. And it does not mention any reason for rescission and does not offer to tender.
So in the words of part of the Janikowski opinion, did that effectuate her right to rescind?
And it preserved her right to sue on it if we didn't respond.
That was you shook your head. Was that a yes to the question?
Yes.
Okay.
Yes, Your Honor. If there's no further questions, Your Honor, I will just respectfully request that this court reverse and enter judgment in favor of the appellant RMS. Thank you.
All right. Thank you very much. We appreciate the argument of both counsel. We're still observing various COVID protocols, which include not coming down to Greek Council in person, which is what we would prefer to do and is our historical practice. So we'll simply give you a nod from the bench and thank you again for your arguments. Hope you will return in the future when all this is gone. So with that, we will move on to our second case, United States versus Whitaker. And while counsel is changing out Mr. Brignac, we're ready to hear from you whenever you're ready.
Okay. Thank you, Judge Agee, and may it please the court, Eric Brignac for Lance Whitaker. We ask this court to vacate the district court's order and to remand to a new district judge for reconsideration. The district court made two separate errors, either one of which would justify vacating the order and remanding it. First, it gave a worse result, or effectively a higher sentence, after Mr. Whitaker's successful appeal. Secondly, it misunderstood one of the material facts underlying Mr. Whitaker's motion, which was the government's response to that motion. There was the presumption and the appearance of vindictiveness in this case. The Supreme Court has pointed out that understanding, yes, Your Honor.
Pretty high barrier to reach, to change judges if we were to vacate and remand. And I look back at the sentencing line in this case, and if I'm correct here, Mr. Whitaker started with a guideline range of 360 years to life, which the district court did not accept, I think, on the government's motion, and he got 276 months plus a concurrent term. And then the district court, at a later time, vacated the 120-month concurrent term, and then later reduced the 276 months to 240 months, and then eventually stayed with the 240 months on remand. That doesn't seem like the timeline for vindictiveness.
Your Honor, the difference between the first motion and the second motion wasn't the 240 months. It was the 10 years of supervised release had been reduced to 8. And then the second time up here, as we're up here now, those 8 were increased again to 10. And the supervised release, Your Honor, is something that this court can look at in terms of vindictiveness.
Do you have a case from anywhere ever where a change in supervised release was a grounds for finding of vindictiveness by the district court judge?
I do not, Your Honor, but this court's case in United States v. Ketter, 908 F. 3rd 61, has established, this circuit joined the majority of circuits, to say that sentencing is unitary. So the supervised release term is part of the sentence. It is not conceptually correct to look at it as separate from the term of imprisonment. Also, Austin v. Plumlee cites multiple instances beyond just the new trial. We have parole boards that increased parole after there was an appeal, and the court said that, citing other circuits, saying that can lead to a finding of the presumption and the appearance of vindictiveness. Because what Alabama v. Smith did, said, look, this isn't going to be mathematical. You know, there was an argument that anytime you get a higher sentence on remand, that must be reversible, that violates due process. Then there were some other cases, and I think the Supreme Court crystallized in Alabama v. Smith and said, no, we're not worried about the numbers. The whole point of this was the appearance of vindictiveness. Somebody exercises a legal right to appeal, be it,
Can I ask
yes,
this
Your
question?
Honor.
So, I mean, the judge here does give a fairly full explanation for why he was not reducing the 240 months and was, as he said, staying with the 10 years. Could a judge do that? So put aside whether it was done here. Could a judge say, listen, last time I went to 240 in 8 months or 8 years, and I did so a little hastily because I'm doing a bunch of these. I now have gotten this guy back on remand. I've taken a closer look at his criminal history, his failure to comply with his obligations in prison, whatever it is, all information that was before me last time, but I just didn't think hard enough about it. But now that I have it before me today, I think really hard about this, and based on all of this information, I really think he needs 10 years, not 8. If the judge did that, do you agree that would overcome whatever presumption might exist and that the court would be fully entitled, even though all that information was available before the 8 years was imposed, the court could totally do that if it explained itself fully enough?
I think in Your Honor's hypothetical,
Right.
that could be the case. I think in...
What do you mean by could? So
Or I
what
think
about
yeah, no,
that
I
would
think-
be a problem?
I mean, I hesitate to say I would want to read what exactly the district court said in that instance, compare it. But yes, I do think it is possible for a district court to say, I am now considering something that I just missed. And I'm forgetting...
Not that I've missed. No, I don't want to say
Okay.
that, right? What I'm saying is, listen, I had all this information before, but we're doing these resentencings based on the various changes in the law. And when I had it before me before, I don't recall doing it, but I thought 8 years was enough. Now that I have it before me again, afresh, I'm looking at the same information, but my best judgment, even though it's the same information, I'm not saying I just missed something, but I'm giving it more considered judgment. My judgment today is this 10 years.
I might have a harder time if a judge says, nothing has changed, all of the evidence was before me before, all of the arguments were before me before, and I'm simply just giving this more consideration. I might have trouble saying that does not at least give the appearance of vindictiveness, which is all we need.
But it overcomes, my point is that would, not about presumptions or whatever in the world that is, but that overcomes whatever presumption might exist, right? Because he says, listen, court, you told me that I have to give him a new sentencing, and a new sentencing requires that I consider it anew. That's the very point of a new sentencing. And I'm doing that. And I recognize that in considering it new, I've come to a slightly different answer, right? But that's the nature of discretionary sentencing. And if he explained all that, then we wouldn't, it's not that that would overcome whatever presumption, if any, existed, right?
Yes, though here, the district court, we obviously...
Okay, that's where I want to go next. You're right. All right, so yes, tell me why the explanation in the joint appendix where he goes through and talks a fair bit about your, terrible criminal, not yours, sorry, your clients, terrible criminal conduct, serious criminal record, poor performance on probation, the need to promote respect for the law, incapacitate Whitaker. The court declines to change his supervised release from 10 years. Why isn't that enough, is what I'm getting at.
3 reasons, Your Honor. First, when he did the first motion, United States versus Martin had come out from this court. It was clear that the court already had to consider all of that in the first motion.
So
Second,
is this the motion where the case then went up to our court and then went on which motion are you talking
I'm talking about the first 404 motion, Your Honor, where the district court did not apply what we now call the Chambers rule. We appealed, asking this court to apply Chambers. The government agreed Chambers should apply and filed a motion for a remand. So that motion.
That's what I thought that's what I described, but anyway. Go ahead.
When we filed that motion, Your Honor, if you look at the reply we filed, Joint Appendix 91 to 96, if you look at the government's response, Joint Appendix 60 to 61, we were already hashing out these 3553A factors. And at Joint Appendix 64, the one-page order the district court issued for that first motion indicated that it was considering the 3553A factors. So the reason this case differs, yes.
Right, but it doesn't say that it considered, I'm not going to quote him again, right, but the terrible, awful, serious, whatever things that he described here, right? It doesn't specify those things, right? It just says generically, yeah, I considered 3553. But here, he's telling us exactly what he considered that led to this conclusion.
Well, Your Honor, I think a rule saying a court's mere invocation of 3553 doesn't allow this court to assume that a district court applied 3553A would have downstream effects.
No, but we've already said that.
But
right? That's the whole blue line of cases.
Right.
You can't just cite 3553. You have to address every non-frivolous argument that is given. Right? We've already said that just invoking 3553 without more means nothing.
And we have a lot more in this case, Your Honor. The parties made 3553A arguments. Again, I pointed to those joint appendix sites. The district court had to consider them under the law. And I guess the point I want to get to and where this really differs from your hypothetical.
If that had been an original sentencing, right, do you think a judge saying, I considered 3553, full stop, would suffice under our case law?
It would not, Your Honor, but this was not an original sentencing. This was a Section 404, as Your Honor's aware of. And I guess the point I really want to say where this really comes away from your hypothetical is I believe, if I'm not mistaken, in your hypothetical, Your Honor said, initially I gave him 8. I am now considering things in a deeper, more fundamental way than I did before, and I think he really deserves those 10. He did not say that here. Everything he said was in justification of effectively going from 276 to 240. He didn't say anything to explain.
That's the fundamental problem here as you see it, is that in terms of the 2 years differential and supervised release, there wasn't a sufficient explanation. Is that your point?
It goes deeper than that, Your Honor. 'Cause not only did he not say anything, which is a problem, but there's nothing he could have said. There was no post-sentencing conduct by Mr. Whitaker. There was no information that was unavailable to the district court between the first and the second motion.
No, but you agreed earlier. I'm sorry.
But
you agreed earlier that you could reconsider based on the same information. It doesn't have to be new information, right? That's discretionary sentencing. It just needs to be considered. It doesn't have to be new information in order to raise someone's sentence.
But it does, Your Honor, if you're going not from 276 to 240, I agree with you there. It does, however, to justify that 2-year difference. There has to be it's not me, it's the Supreme Court has said, this court has said, something must affirmatively appear on the record. And
yes, something must affirmatively appear on the record, but it doesn't have to be new. It doesn't have to have happened since the prior sentence. But it just has to be something that was not apparently considered the first time, right? And we've got all that here. I mean, he's got a whole list of things here that he didn't give before.
And I guess, Your Honor, where I just disagree as a factual premise is to say that the district court did not consider those. He went from 276 to 240. He made a substantive change. So the record shows that the district court did consider those factors. So I think where you and I disagree and where I respectfully disagree is the factual premise or assumption that what he was relying on when he gave this more fulsome order wasn't something he already relied on, even though he didn't write it down. I saw Judge Quattlebaum. Did you have a question?
I was kind of getting to the same point, so I don't have anything else.
Okay, sorry, I just didn't want you to miss
appreciate
that. This obviously, that all gets to the questions of vindictiveness, Your Honor. The other point we raised is that the district court,
So why wouldn't this just be a very simple case about lack of explanation for the 10 years as opposed to 8 years?
this,
I mean, I don't
this
see-
Your Honors,
The vindictiveness to me just seems like you've stretched way above anything that's reasonable. And it's really a very simple case,
and
if you have one, that's more of an amended blue type problem.
And that is certainly a way that this court could conceptualize this case. I can tell Your Honors that a lot of that vindictiveness, it was driven by the appearance. Whatever members of the general public are paying attention to Lance Whitaker's case are basically Lance Whitaker and his family. And that was very much their first reactions upon getting this second order, calling me, talking to me about that. But I totally understand why this court may not want to reach the vindictiveness issue. But even then, there still needs to be a remand because, as Your Honor pointed out, there would be a problem with the explanation between going from 8 years to 10 years. The problem I also want to say, and I don't think
Can I
this...
ask just maybe a
course.
practical question, and this is just like my curiosity? So why in this scenario, why did you not file a motion to reconsider? Like after this came out, why bring this to us as opposed to bring it to the judge's attention and say, hey, judge, by the way, in our prior motion, we didn't mention that you did this because we want 4 years, not 8 years, but you previously gave us 8, you just gave us 10, and you didn't really explain yourself super well on why that is. Like, it looks a little bit like a Scrivener's error. Like, can you clarify? Why not?
Yes, Your Honor. Rule 35, Rule 36 motions, we tend to file those. Those tend to be most appropriate. If, say, you have an oral sentencing hearing and then a written judgment, and you compare the transcript to the judgment, you realize, the court had a hearing, the court said X, and it wrote Y. And
Right,
so,
but here, you could do it here, right? And like you chose, like what I'm trying to understand is like, why are you bringing this to, I don't mean this in a bad way. But
No, yeah.
Why not just go to the judge and say, hey, this doesn't seem to make a lot of sense?
well, because, Your Honor, it was as Your Honor has pointed out, a somewhat thorough order. It did not, on the face of it, appear to be a Scrivener's error. It did not appear to be something where the district court didn't realize what it was doing and wrote an 8 when it meant to write a 10, or wrote a 10 where it meant to write an 8. And I think that's just the way these cases go. Your Honors have cited the blue line of cases, and it's just not typical when there is a sentencing hearing to, instead of appealing, to file a Rule 35 or a Rule 36 based on lack of information that this didn't explain. This, to me, in Your
understand
Honors...
why that is. I mean, this is the concern. You might say this is the reason why we have concern about the lack of a need to specifically object, right? Because since you've made some general reference to 4 years, you've preserved all objections all time. Instead of, when it says to not change his 10-year sentence or 10-year supervised release, when it was in fact a change, seems like a Scrivener's error to me.
And, Your Honor, I understand it may be a Scrivener's error. It certainly has the appearance on its face of vindictiveness, which is why we raised a vindictiveness claim. And it may be that, getting to the blue line of cases, Your Honor, it may also be that the district court did not give a thorough enough understanding, misunderstood what it had done the first time, as the government alludes to in its brief. So there's different things this error could be.
Anything you haven't told us in response to Judge Richardson? that you-
I'm satisfied with my answer.
Satisfied? All right, thank you, Mr. Rignall.
Yes.
You've got some rebuttal time, Mr. Rogers.
Good morning. May it
Can you-
please the court.
Can you start with the question I ended with your colleague on? So tell me why, your job as an AUSA is to help the court. You're an officer of the court. When you get this order and you look at it, it looks a little bit like not change 10 years when it was previously 8, looks like a Scrivener's error, right? So why didn't you ask the court to take a look at this and either provide clarification as to why it needed to be 8 or to correct the Scrivener's error?
Because the United States does not believe it was a scrivener's error. That's an alternate argument. There wasn't anything that needed to be corrected.
Well, this is a pretty detailed order from Judge Dever, and it seems like to me if this were an initial sentencing, he would have really nailed it and in terms of what he needs to say, but it struck me that having gone through all this detail about the history of the case and why he was giving Mr. Whitaker the 240 months, there's never a mention of the pre-remand sentence where he had the 8 years of supervised release. And it just struck me as odd that to have gone into all this detail, but to have left that out does raise a question, it seems like, that the district court might have overlooked something or been confused, because it also noted that the government responded in opposition, which if that means they opposed Mr. Whitaker's request, part of that would have been incorrect, or whether that was just the way of saying that they filed the pleading. But it just seems odd to me that you have such a detailed opinion that leaves out that crucial fact.
Well, the court impliedly raises it. JA 115, just before the Roman numeral 1, that last sentence says, as explained below, the court again reduces Whitaker's sentence to 240 months imprisonment on count 5, but denies Whitaker's motion for a further sentence reduction. The court is referring to the rest. The court is effectively saying, I'm not giving any less than was given before. But the important thing that defendant
No, but wait. I'm sorry. I just want to understand your argument. Your argument is when he refers to further sentence reduction, you read that to encompass supervised release.
Yes, Your Honor.
But you could also reasonably read it to not cover supervised release, couldn't you?
Because on 119, he uses that same language, right, to further reduce his sentence below 240 months or change supervised release, suggesting that further reduce, it does not include supervised release, right? He uses it separately in those two different places, right?
Well, that's where we get to the alternative argument that we made in footnote 7 of our brief. But we don't even have to get to that argument because defendant actually points out some very helpful language in the Austin case in which it says that the court has to include information that sheds new light on its decision. Well, we have new light. There was no light before. All we had was two numbers, 240 and 8. The court has chambers that comes along and says, oh, here's what the new light needs to look like. So the court started over, looked at 2010, shed the light for us to see, and we look at this order that goes on at length about the defendant's, for example, offense conduct. It goes into his primary income, how much money he was making,
But counsel, it does do that, and but doesn't that argument at least do a lot to read away or ignore our Abid case? I mean, it seems like I think it's a fair question of whether this was any sort of vindictiveness or an oversight, but, just as a matter of fact, the supervised release went down for 2 years, and there was nothing that said, here's why, or went up 2 years, and there was nothing that said, I'm going up for 2 years because of X, Y, Z. So at a minimum, we got to imply something from there that okay, I'm giving a more thorough review or whatever, but I mean, don't even if it's just a technical, non-vindictive situation, doesn't there need to be something that acknowledges the increase and why?
I do not have any case law that I can find that says the district court has to say, well, last time I did this and now I'm doing that. What the law requires is that there is something in the record. If we look at Alabama, it says Alabama v. Smith, any unexplained change in the sentence is subject to a presumption of vindictiveness. This is an explanation of its sentence. If we look at 119, where it's explaining why it's doing, it's an interesting sentence. If you go about 1, 2, 3, 4, 5, 6, 7, 8 lines up, it starts with Whitaker has.
Lines up from the bottom.
Yes, sir. The sentence starts, Whitaker also has performed.
Right.
The court says, Whitaker also has performed poorly on probation. However, Whitaker has taken numerous positive steps while incarcerated and has no disciplinary infractions. What the court is doing is it's contrasting defendant's probationary behavior and it's contrasting it with its behavior in prison, which makes sense that the court would go back to 2010, look at it and say, you know what? Now that I look at this, defendant really struggles with probation. We need to reflect that a supervised release term will oversee defendant in a way that perhaps 8 years didn't.
And you know, if there had been an extra 2 sentences in this opinion that said that, I don't think we'd be hearing this case.
I would agree with that, but
It seems like to me here that, despite opposing counsel's argument, it's pretty hard to make a vindictiveness case here, but there seems to be a blue-type explanation problem, and what you just described, I think, illustrates that. Now, maybe that shouldn't be the state of the law today. The law professors and law review articles can argue about that, or Supreme Court can take it up, but we require a pretty detailed and specific explanation. And you just gave that. It was a very good one, but it's just not in this opinion.
right. Well, the blue problem was with its order in 2020. The blue problem isn't the problem here. The problem in these cases is if there's no explanation. The court gives its explanation. Twice it mentions the defendant having a problem cooperating on probation. The court is in an...
Right, but which way do I take that, right? Because I could take that 2 different ways, right? So I could say, listen, he's terrible on probation. Therefore, I'm going to give a longer prison sentence and a shorter probationary sentence, right? Because if he's not going to do well on it, he needs to stay in prison because that's going to actually restrain him. And that's part of what I'm trying to do, right? Incapacitate his criminal activity. Or I could take it the direction you're saying, which is, well, since he's so bad at it, we should give him more of it. Like, I don't know. I'm not sure whether I don't know which way to go on that, right? Like, the fact that he's terrible on probation could justify either lengthening or shortening his supervision, right? I mean, we've all been in courts where district judges say, I'm going to put you back in jail for 8 months, but I'm ending supervision for you because you're simply incapable of complying. And so we're going to give you a longer prison sentence as a result of your violation, but then I'm going to end your supervision because it's just never going to work.
Well, as Your Honor said previously in this oral argument, that's the nature of discretionary sentencing.
Totally fair, but you got to give that's the point, right? My point is we can't infer which of those is the case from the fact that he says he's terrible on probation. We don't know whether the judge thought that means you should get more supervised release or less supervised release. And either of those answers would be supported by the information he gave, right? I think that's the link that Judge Agee's reflecting. He could say either of those, right? And if explained, we would say, great, that is discretionary sentencing. You get to pick. Either way is fine, right? It's a reasonable judgment. But you got to say.
Well, in this case, the court said quite a lot. Probation's not the only thing he mentioned. He is explaining why it is he's doing what he's doing. He does not have to go into an explanation and compare it to what he did in 2020. And the thing that should be our North Star here is that the defendant has an extremely high burden for good reason, because vindictiveness is not a term of art. It means something. If we say we can presume that Judge Dever acted vindictively, this is a very serious allegation, so he's got to show...
Right, but what we're talking not about vindictiveness, if you hadn't picked up on this yet, right? So we're talking about a failure to give a full explanation. And that, for better or worse in this circuit, happens all the time, right? And so that we're trying to figure out whether there's enough explanation And if he had given what you just said, which is he's terrible on probation, therefore he needs more of it, we'd be done, right? But he didn't make that last link. That's the concern that I've got, at least from my perspective.
And it's our argument the court did not have to make that link. A court could just simply say, this is what I'm doing now. The
So
chambers,
that argument, counsel, is that if the reason, if the explanation for the sentence is reasonable in and of itself, there needs to be no mention of why it's being increased from the prior sentence.
it doesn't have to bring that up. No, I mean, this
That's
court
well, I'm sorry. Go ahead and answer. I got to follow up. I'm sorry.
the court can still review the sentence for procedural and substantive reasonableness. If that's part of the court's equation when it comes to substantive reasonableness, well, that's part of this court's equation. But that doesn't mean that the district court has to go into an explanation of why it did something in 2020 that was entirely vacated. It's been wiped out, and now the district court is doing what it has to do. It's looking at 2010 and saying, okay, now that I look back, I'm going to shed new light. In fact, I'm going to shed light. There was no light before. And I'm going to explain exactly why I think it's appropriate to reduce the amount, but to say, you know what, 2010, I actually had it right with those 10 years. That's entirely appropriate. That's the new light.
That would be appropriate if he had said that. He just didn't say that.
Yeah.
It would be ideal, but it wouldn't be inappropriate. It's not inappropriate for the court to have done something other than that. And because this is, the issue here is not procedural reasonableness. Beyond this, the defendant pointing out this statement of the government's position, the issue here is vindictiveness. And I think we need to come back to that, because that's the fight defendant wanted to pick. And it's a very serious fight, which is why this court has a high standard.
Why? Let me go back to, I just want to make sure I understand the argument. So when the court says that it declines to change his 10-year supervised release, right? I just have a hard time understanding what that could possibly mean. It was 8 years before. If he's not changing it, it would be 8. I mean, I know you began the argument by saying, oh no, that can't possibly be a Scrivener's error, right? Or like, that's not a Scrivener's error, right? But I don't understand how that can be anything other than a Scrivener's error. That like in the, life that we live, like that's just like a mistake. If he was saying, I'm not changing it, and then he says 10, I have trouble putting that together. Help me understand how I see that other than like just a Scrivener's error.
I'm not saying it's impossible for it to be a Scrivener's error. Like I mentioned in footnote 7, we acknowledge that in the alternative, there is this mystery sentence where you have a dependent clause and an independent clause interacting, and it indicates that Judge Dever believed that in 2020, he handed down a 10-year supervised release sentence. Well, let's assume that's the case. The court's saying, I'm not going to change that. In other words, I don't want to go up from that. It's showing the court has no intent to be vindictive. It's not anymore.
Let's just assume that, for purposes of argument, that vindictiveness is off the table. What's the harm in sending this back just to say to Judge Dever, we don't know why you did this. Tell us why you did it.
I mean, that's an option that's on the table, but argument would be.
So what I'm asking you, what's the harm in doing that?
The harm in doing that is that we have an order that we believe is clear enough that the court intended to do what it did. And you have a judge that's being asked again to redo this when the court has done its job. And he has the Fourth Circuit saying, you've made another mistake, when we can't see that mistake here in the way that the defendant is saying.
But maybe he didn't make a mistake. Maybe it's just we can't understand why you did what you did. It doesn't mean it's a mistake. I mean, he may have, if he'd used the language that you recited a few minutes ago, as I indicated, I don't think we'd be hearing this case. But if we can't tell, don't we usually in that circumstance send it back and tell the district court judge to explain himself or herself so we can understand it?
If the court opted to do that, then it would, would it be a miscarriage of justice? No, but in that case, we would ask this court to affirm the judgment And if the court is inclined to conclude that the district court's decision was influenced by a misunderstanding of what it did in 2020, that the case be remanded solely to address the clarification with respect to the term of supervised release. That would
Unitary sentencing, right? So like if we send it back, we just send it back, right? We don't get to pick and choose, right? Hadn't we said that repeatedly now, that you don't get just to reconsider part of it. Once we send it back, we're sending back the whole thing. Now, all it would mean is he takes the same order, he changes the word change to increase or whatever it is, right? I mean, it wouldn't take a lot of work to make that change, but he'd have to do something, right?
Therefore, in response to Judge Agee, would it be harmful? Not necessarily. Is it necessary at all? No, it's not. Especially, again, getting back to the issue that's here. Defendant didn't argue procedural error. Defendant argued vindictiveness. Vindictiveness, you look in the dictionary, it's not a very polite term. It means spiteful. It means vengeful. So this is what he said. Like I said, this is the fight he brought to the Fourth Circuit, and it was an unnecessary one, when indeed the defendant could have simply raised his hand and said, in a motion for reconsideration, Judge Dever, it appears that there has been a Scrivener's error or whatever he wanted to bring to the court's attention. And that's why
But isn't it true now, like our case law is like set up for him to sandbag that, right? I mean, it'd be a violation of his obligation to his client if he did it at some level, because we've told him, you get to sandbag, right? That like, as long as you put at the end of your motion, we want 4 years of supervised release, you don't ever have to say anything about it, and you get to come here with a preserved error, right? We've told him to sandbag, right?
I don't know that the court has told him to sandbag, but I do believe that he can certainly do so, but I do think it makes us pause and say, wait a second, are we really looking at vindictiveness here, where the court very likely had a Scrivener's error, or it did exactly what it wanted to, and the defendant is now willing to say, oh, wait a second, now we have a problem when we have a district court that never got a chance to fix it? The burden is high when it comes to vindictiveness. This defendant had to show there was a reasonable likelihood that Judge Dever acted vindictively. The fact that we have had to discuss in so many different ways what he might have been doing leaves us with the question, can we really say there's a reasonable likelihood of vindictiveness here? If defendant had argued that there was true procedural error, perhaps we would be having, or should be having, a different discussion. All he did when it came to procedural error was say that the court misstated the United States position. That's not enough for the remand on a procedural error where the district court didn't even rely on that, and we can see that based on what the court did say. Under Gall, that's not going to be enough. If that's all he's got, this isn't a procedural error, and that's not enough to remand this case, and it certainly isn't enough to find that Judge Dever acted vindictively, or at least that we can presume he did. Therefore, we'd ask this court to affirm the district court.
All right, thank you, Mr. Rogers. Mr. Brignac, you've got some time in rebuttal.
Thank you, Your Honor. I will take this court's invitation and say vindictiveness is off the table for purposes of this rebuttal. I will say we did take that very seriously, and we talked about the appearance of it and how it looks to the outside world, and I think that was there, but I think we can spend this 5 minutes more productively. And yet, Your Honor, I always tell everyone when it comes to appeals, you want to win. The best way to win your appeal is to make the other person have to appeal. So there really was no sandbagging here. This never struck me as appropriate for a Rule 35 error, and we certainly try to win our cases in front of the sentencing judge.
That was not a personal critique of you.
Right.
Your obligation is to your client, and
right.
If your client, and so I'm not. Please don't take that in any way as a critique of you. But you get my point. That you have no incentive to raise that at a Rule 35 because you can come to us on a preserved error.
Yes, sure. I will say that if there's an error I think I can get fixed without making my client wait 9 months and taking the chance of coming up here, there is the incentive, the practical incentive. But I do think, Your Honors have all, spent 20 minutes.
I think he's got a while before we get to the supervised release, right? Like 9 months is not a hang-up for him, right?
Fair enough, Your Honor. Very good point. Your honors all spent 20 minutes going back and forth with the government about what district court order could have meant, or did it mean this, could he have implied that? And as your honors all realize, that's because the order was procedurally unreasonable. We raise this as vindictiveness, but the Provence case indicates that this court can and should raise procedural error sua sponte. The lack of explanation, and Judge Quattlebaum, I think you were right. We don't often have cases where it goes down to the district court, up here, back down to the district court. So there is a fundamental difference between this case and almost any other, which is we have this intervening 2020 district court opinion, and to not even address that, to not even acknowledge that, to not even give an awareness of that case's existence is procedural error, especially when he gives those 2 extra years of supervised release. When you combine that with the mischaracterization of the government's position, that sort of compounded procedural error. And that matters more in this case than others because, as Your Honor first opened this oral argument by pointing out, the government did have a 5K motion. So in a cooperation sentencing, the position of the United States is more important than it is in other sentencings. The United States explains the cooperation and gives a sentencing reduction recommendation. It's simply more intimately involved because of the nature of cooperation. And Mr. Whitaker really did cooperate. He wore a wire. He was communicating about things he learned in prison. So the United States, when it comes down for this second remand, very much not taking a position, which is rare. In most of these 404s, they do say, please exercise your discretion not to reduce. Not taking a position, I think, spoke to Mr. Whitaker's cooperation and the fact that they do think he should have gotten somewhat more of a reduction, or at least didn't want to argue for lack of reduction. So it was a more significant procedural error. And the government, I would also just want to end by saying this court's clearly not going to reach vindictiveness. It does not need to reach vindictiveness to address the question of whether to remand to a different district court judge. The second and third prong of that test, most of the time there is a remand to a different judge. It's because of the judge got involved in plea negotiations or he heard information he shouldn't have. So you do not need to find vindictiveness. The second and third prong, would reassignment preserve the appearance of justice? Would it waste resources? I think here, considering certainly the reaction my client had to this order and just the fact that he did go up without any explanation, it would preserve the appearance of justice to go to a different district court judge. And because everything involving this 404 motion has all been on the papers, he's had no in-person hearings since his 2010 sentencing, I do not think it would be a duplication of resources out of the ordinary to do that. So for those reasons, Your Honor, we do still argue for the vindictiveness finding, but perhaps more appropriately, do think this case needs to be remanded because the district court's order was procedurally erroneous, and we do stand on our request for remand to a different district court judge.
All right, thank you very much.
Thank you, Your Honor.
We appreciate the argument of both counsel. As you can see, we're still COVID restricted, so we can't come down and greet you in person, but we hope to the next time you're back. So with that, we're going to take a short recess, and we'll come back for the rest of the docket.
My name is Lindsay Ruff, and I represent plaintiff appellant Justice 360 on behalf of Boyce Schiller Flexner. The South Carolina Department of Corrections has interfered with Justice 360's First Amendment rights by placing content-based restrictions on a tool of political speech. Specifically, appellee has invoked the AG's interpretation of the secrecy statute to selectively withhold information about the impending executions of Justice 360's clients. Strikingly, appellee has done so in an open effort to suppress judicial oversight and critique of the capital punishment process. Appellee's interpretation and application of the secrecy statute transgresses the First Amendment for 3 reasons.
So let's talk to us a little bit about standing first.
Sure.
'Cause here you have, you're not threatened with prosecution. Whatever information you have, you're free to say whatever you want to about it to whomever you want to. So it's hard to see on the surface that you're censored or self-censored in some way. Tell me why it is that you have standing here.
Sure. So the relevant injury, in fact, is the burden to speech that Justice 360 has suffered due to the discriminatory treatment from appellee's content-based restrictions on disclosure of
How are you discriminated against?
Because appellee has disclosed this information to certain speakers but not others, and for only certain purposes for not others.
But the certain speakers that they disclose it to is you.
They've disclosed it to certain Justice 360 attorneys, but not other Justice 360 attorneys. And the only attorneys they've disclosed it to are those who've been willing to relinquish their First Amendment freedoms to discuss the protocols and the
Sign a confidentiality agreement that they chose to sign. They relinquished it to you, though, right? I mean, it's hard to say that that's like speaker discrimination when you're the speaker that got it.
Well, first, appellee has historically disclosed the information more broadly than just to Justice 360.
And we have lots of information in the record for why states all across the country have changed that approach, right? Because they had the belief, at least, that the information was being misused. So put aside the history, right? What I'm trying to understand is like why you think it's speaker-driven when you are the one that's getting it.
We would say it's speaker-driven in that only certain attorneys, those who are willing to relinquish First Amendment freedoms, are those who have given access. And we would say
That's on behalf of a specific client, correct?
That's correct. That's correct. So the reason that certain Justice 360 attorneys sign those confidentiality agreements is that they have duties to zealously advocate on behalf of their client and act in those clients' best interests. And given the time crunch with impending executions on the horizon, they felt getting access to some execution information would be better than none at all. So they were put in a position where they felt they had, acting in the best interest of their clients, they had to sign those confidentiality.
So they're acting in the interest of their client, but you're not here on behalf of any client.
Exactly. So Justice 360 isn't challenging those specific confidentiality provisions. They're challenging this overall practice of withholding execution information absent an agreement to relinquish First Amendment rights. That's the content discrimination. That's the discriminatory treatment that is giving rise to a First Amendment burden here.
Can I ask a question about the information that Justice 360 got on April 14th that we just learned about? Was that pursuant to a court order? Was there a court order that authorized that disclosure?
No, that was pursuant to a confidentiality agreement that was worked out between the parties, but that Mr. Moore's execution has since been stayed.
We're familiar. And the same thing with Sigmund, that one also was not pursuant to a court order.
Correct. That was pursuant to an agreement between the parties. But both Sigmund and Moore's executions have been stayed, so that information is no longer operative because the certification process will have to restart. And Justice 360 doesn't know what methods of execution will be certified as available at that time, let alone what the specific protocols for those methods will be. Nor does
so if that's true, if what you're saying is that information is no longer good, right? Because the execution stopped. What information do you think you would get, right? So your information wouldn't be good either, right? So you're asking for information that you've just told us is not pertinent anymore because it hadn't been certified.
Well, we're asking for if and when a new execution date is set, and methods of execution are certified as available, whether that be electrocution, firing squad, lethal injection, or some combination of the three. At that point, Justice 360, we're arguing, would be entitled to get access to the protocols for those methods so that it can...
So do we agree now that there are no executions that are currently set in South Carolina?
That is correct, although Freddie...
And that one might say, given the South Carolina Supreme Court's order, it's unlikely that any will be set until at least one or two cases go before the Supreme Court.
That we disagree with. Freddie Owens has exhausted his appeals process, and we would expect his execution date to be set at any time.
And do we have any reason to think the South Carolina Supreme Court is going to view his challenges different from the prior challenges that the South Carolina Supreme Court has stayed the executions on?
It's difficult to assess because in staying Moore and Sigmund's executions,
We don't know is your answer.
Correct, because the
Right,
Supreme...
so then why is your case ripe? Right? Why hadn't you just said to us, yeah, maybe if they set an execution at some future date that we don't really know might happen, then Justice 360 wants information. That seems like what you just told me.
Our position is that the case is ripe because there are several Justice 360 clients who have exhausted their appeals process, and the ball is in the state's court to set their execution date.
You agree you can't get the information until, because the information is not set or certified until the execution is set, right?
We agree that our right will arise once certain methods of execution are certified as available, and at that
But until then, you agree you have no right to that information.
The difficulty is that this...
No, answer the question first and then explain the difficulty. You agree until an execution's set, you're never going to get information, and you don't want the information because it's not certified.
Agreed. The difficulty is that this is an issue capable of repetition yet evading review because of the moving pieces and the compressed timeline in which these execution dates happen.
And so
Once
that
an
gives you standing?
I'm sorry?
That gives you standing?
Yes, that gives us standing because once an execution date is set, Justice 360's clients have 8 days to elect a method of execution. So Justice 360 needs that full 8 days in order to consult experts.
Go back to the content discrimination. Is your argument that because in prior years, either your organization or others got certain execution information, that forecloses what may happen in the future?
Our argument is that the state has engaged in content discrimination in multiple ways. One is that there was this historic practice, the status quo, marked by uniformity and transparency, but appellee changed that status quo in response to the, quote, actions
In
of...
response to Judge Richardson, didn't you at least admit inferentially that whatever that information was, which you have, isn't really effective anymore? So how do you get to content discrimination that way?
So the issue is that the state has historically disclosed this information, but has now instituted this new regime where it's arguing it has full discretion to either withhold execution information or disclose execution information entirely at its discretion, and as it has done so far, only if attorneys agree to relinquish their First Amendment rights to discuss those protocols publicly, and in some cases to discuss those protocols in the context of lawful litigation.
But you're not here on behalf of a client facing execution. You're here on your own peculiar, separate, organizational, institutional basis, which, as I understand it, you tell me if this is not right, is that you need this information so you can engage in political speech.
Correct.
That's correct? So why is this case any different from the Supreme Court's decision in Houchins way back when, or LAPD versus United Reporting? Because the arguments raised by the plaintiffs in that case seem to be almost on all fours with what you raise here.
So Justice 360 concedes that appellee could have chosen to never disclose this information and to uniformly withhold this information going forward, but that is, in that case, the Houchins rule that there is no general right to access government-controlled information would apply. But that is not what's happened here. Appellee has selectively disclosed the information when doing so would facilitate compliance with the capital punishment scheme, but has withheld information in an effort to discourage scrutiny over the capital punishment process. And as we just discussed, formerly had...
Well, how is that different from Houchins, though? Because that, in that case, it was over access to the jail, and the plaintiffs specifically argued that they had to have that in order to participate in the public debate. But there was an ongoing process where the sheriff would allow a certain number of folks to tour the jail. So how's that any different from this case?
So in Houchins, for example, there wasn't a situation where the state was saying you can come tour the jail if you agree to not speak about it publicly, to not disclose what you have seen here. And only people who will sign a confidentiality agreement agreeing not to disclose what they see inside this jail can come in. That's not what happened in Houchins. That's what's happening here, and that's content discrimination. And in Fusero, this court correctly recognized that such content-based restrictions on government-controlled information can amount to a free speech violation. And that's also what 8 justices recognized in United Reporting as well.
Does the Fusero case, to the extent it talks about, an exception, if you will, or some window that's separate from Houchins, it seemed to be based primarily on information, or largely on information, that the information was being disclosed to some people, Maryland residents, and not the petitioner there. Is your argument how you fit into that, the fact that other Justice 360 attorneys have received information? Is that how you say we fit within the Fusero approach?
Yes, it's that historically attorneys...
Well, forget the historically. I don't mean to cut you off. I'm talking about now, because, the historic is, I get that argument. I'm not saying I'm not considering that, but let's don't talk about that. Let's talk about contemporaneously, because that's what was going on in the Fusero situation, I think.
Yes, that is our argument, that only attorneys who agree to relinquish First Amendment freedoms access this information, whereas attorneys who won't relinquish those freedoms are unable to access this information.
But there wasn't any barrier in Fusero on the residents who received the list as to what they could do with it or who they could give it to.
There was a barrier in Fusero for residents who received the list what they could do. Specifically, they could only use the information, I believe the language was for purposes that relate to the electoral process. So the court considered both the speaker conditions and the content restrictions.
Well, they couldn't use it to go out and solicit people to buy insurance. But if the plaintiff in Fusaro had approached somebody in Maryland who had the list, there wasn't any barrier on him obtaining the list from them.
Correct, but that, again, it isn't the situation here due to these confidentiality restrictions that appellee has imposed. So in that way, this case is sort of like the Overbay case, which talked about the pervasive use of non-disparagement provisions and those kinds of restrictions on speech giving rise to First Amendment harms.
So the attorney-client privilege here, where the disclosures made, in your view, that's where the state of South Carolina has made a mistake that gives you an opening.
The attorney-client, I apologize, I'm not sure I understand the question.
Well, you have all these cases that come up where the individual defendant is the one who is requesting the information for their execution. So their attorney is receiving the information. So why isn't the attorney-client privilege something separate and apart from any type of content issue?
So this case, as you noted earlier, we're bringing on our independent behalf due to our freestanding First Amendment rights as mission-driven litigators. Those were the sorts of rights recognized in the NAACP v. Button case and the In Re Primis case. So whether or not inmates have any sort of particular Eighth Amendment or due process or other interest or ability to access this information, that's not what we're arguing today, and that's simply not the question before the court.
Right, but the question to you, though, is that the state of South Carolina is making some disclosure to attorneys under attorney-client privilege. And I take it that your position is that because they do that, that allows you to evade all the other Supreme Court cases and the Fusquero case, and that's the mistake the state of South Carolina makes as far as you're concerned as an organization.
As far as our concern, yes, the mistake that has been made has been restricting disclosure to recipients who relinquish their First Amendment rights.
Can I ask a slightly different question? Imagine instead of what we've got here, we got a grand jury investigation, right? And so certain grand jury information is needed by a lawyer representing their client. And they're entitled to that information as a result of representing their client, but they are required, pursuant to the grand jury Rule 6E, to not disclose that beyond their representation. If South Carolina adopted that rule, is that a content-based restriction or speaker-based restriction? That seems like exactly what we've got here. And that doesn't look at all, this is, I think, tying into Judge Agee's point, like that happens and we don't consider that disclosure of grand jury material as waiving grand jury information for all people in all time, right? Instead, it's narrowly tailored to that story, right? That you get it for this purpose and this purpose only. It seems like to me the state of South Carolina has just adopted Rule 6E for this information.
Well, in those sort of cases, I mean, you could imagine a case where, for example, a media organization would intervene and say they need access to that sort of information.
And they are
for public
denied
disclosure.
every single time, right? They continue to ask for that information and nobody gets it, right?
And presumably that would be due to an overriding state interest in secrecy. If the state here is able to articulate some overriding state interest in secrecy.
No, it's not. It's based on it. That's the rule.
Okay, well then that it's also based on sort of deference to the legislature, these existing rules. Whereas here, the rule on point, the plain text of the rule only says that the identities of the execution team members can't be disclosed.
Right, but they've got the discretion to make that choice, right? That's what I'm saying. It's like, that doesn't make it a impermissible content-based regulation or decision merely because you say, we're gonna give it to this narrow set of clients who need it in order to defendants who need it to preserve their rights, that opens it up for all people at all time. And I'm trying to understand how that gets you to Fusquero, maybe is the rub.
Sure, so I think the issue there would be if the state instead said, we'll only give it to this narrow subset who need this information if they agree to not disclose the information to the public.
That's what they do in 6E. That's exactly what they do in 6E, right? They say, we'll give you the information, but if you disclose it, you're gonna go to jail.
Well, and if there was a historic pattern of disclosing this information without incident. Again, part of the content.
It really does come back to you that South Carolina, having disclosed this information before, cannot change that practice now, given the misuse of the information that they used to provide. That's the sort of crux of where we are.
Correct. Our position is they can't change that status quo now on a content and viewpoint basis, which they have openly done.
Even though the content you got before would not be the content you'd get now.
The content we got before would be the content we got now, but just updated to reflect.
No, it couldn't be the same. I mean, if you've already got what you needed, you wouldn't have a case.
And that's why we would need a declaration on a go-forward basis, because execution protocols change for each inmate, including because the training and qualifications of the execution team change with each execution. So
you're a little over time, but what's your best case where the disclosure of information under the attorney-client privilege has separately created content discrimination for First Amendment purposes?
I would say, I mean, the issue of that exact case, I don't know if one exists off the top of my head. I mean, this issue of restrictions on access to government-controlled information amounting to content discrimination is a fairly novel line of cases. Fusquero expressly acknowledges that it's the first time a court of appeals had dealt with this issue. But there are cases dealing with similar issues. For example, in the Ham v. Dunn case, which was in Alabama and related to the disclosure of execution protocols. The court ordered disclosure, noting that it needed access to the protocols in order to make an informed assessment of the constitutionality. And when a media organization later intervened to get access to the protocols, it disclosed those protocols and then actually carried out the execution without incident. So there are other cases of this information being made public, of states nonetheless being able to carry out executions, and of courts recognizing that disclosure of this information is not.
You don't have a case in the attorney-client disclosure context that relates to First Amendment content discrimination?
In the attorney-client disclosure context, I don't have a case off the top of my head. I would be happy to follow up with supplemental briefing if that's the specific question you're interested in.
You've got some time left on rebuttal, so we'll now hear from Mr. Hall.
Thank you, Judge Agee. Gentlemen, may it please the court?
And if you wish to remove your mask, you can.
Thank you. I appreciate that. I am Kevin Hall. I represent the South Carolina Department of Corrections and its Director, Brian Sterling. Let me begin by hitting the standing issues that you raised. I don't want to spend a lot of time there because I think those issues are well framed. The court has posed questions to the parties, which we have answered. We do not believe this issue is right. We do not believe there is standing. Similarly, at the district court level, we argued for the district court to abstain, slightly different grounds, but the same notion that the issue wasn't ripe, it wasn't appropriate for the federal court to engage at that point. So we do believe that this case should be dismissed for lack of standing. We don't believe that the issues are right based on the certification distinction that Your Honor just discussed with counsel.
What about opposing counsel's argument that it's capable of repetition but evades review because the timeline in these things is so short?
Well, look, I understand the argument. I can say that there have been no fewer than, I think, by my count, about 9 cases filed, all of which have been dealt with in those timelines. I understand that there is a short timeline, but there is no circumstance in which anyone's been executed.
9 cases filed by the actual defendant?
That's right. That's right. 9 cases. I've got a chart here, a color-coded chart that shows it all going on so that I can keep track of it. But that's a theoretical articulation. I understand the point made, but there's just no history. And I think we all know as a practical matter, there's no way anyone's going to be executed on the basis of a timeline like that. So again, from a standing perspective, we do not believe they're standing. If I could shift.
Before you shift, can I ask a question? I'm just trying to figure out a little bit what happened. So the April 14th disclosure that was made to Justice 360 or some subset of Justice 360 on behalf of their client, that was not done pursuant to a court order, right?
That is my understanding. I will caveat what I say with I'm not counsel in those cases, all right? So
let's hypothesize they are, and she represented it wasn't, so I'll go with that. But Kat, assume for a minute that it was not done pursuant to a court order. Doesn't that tell us that was the director then exercising his discretion to disclose the information, some information, but not all, under that he believes is not part of the Secrecy Act, right? Because the Secrecy Act says you can only disclose information that would reveal the identity of a executioner, with a court order, right? And so, but not all information falls in that bucket, and I'm not trying to make a judgment of what does or doesn't, but by disclosing it to Justice 360 with a confidentiality agreement, isn't that the judgment, or shouldn't I read from that the judgment that the director determined in the exercise of his discretion to make that disclosure, and thus his belief that information is not protected by the Secrecy Act itself?
I want to be careful here, Judge.
Yep. If I'm asking, I want you to be careful.
I think the department Department of Corrections certainly reserves all rights with regard to what its latitude is and whether a court order is required. So I don't want to describe or characterize.
So you do not accept so I should have asked this question first. I'm glad you're being careful. Does the director have the discretion to disclose information covered by the Secrecy Act without a court order?
I would want to study that more carefully before delving into it. I understand on the face of the statute what drives Your Honor's question.
I mean, it looks that way, right? And if that was true, then the director's disclosure would be at least his belief. Now, his belief is not, binding on this court, of course, but would be his belief that the information that was disclosed is not covered by the terms of the Secrecy Act.
Well, again, I don't want to put words in my client's mouth there, so I'm going to.
I understand. I'm not asking you to.
I'm going to dodge that. I'm going to say that assume for a second that a court order is required for certain information, and assume hypothetically, for the purpose of argument, the hypothetical that you've proposed, the First Amendment issues don't change. All of the issues in this case don't change. The analysis that we would go through in terms of Fasaro, in terms of Houchins, in terms of United Reporting and so forth, don't change. So I don't know that
So that's true, but it might change the standing analysis. That's why I'm asking it. I'm not asking it for the merits. I'm asking it for the standing.
Well, again, from a standing perspective, that information would be stale at this point anyway. Now, look, if that clearly there's going to be an opportunity in this case for a do-over. That's the nature of these.
So it may make a difference in ripeness. It may affect the injury, but it doesn't affect ripeness.
Well, I think in terms of ripeness, regardless of how this issue works out, Judge Richardson, ripeness doesn't exist here. Okay, we're talking about stale information, in Judge Agee's terminology, stale information at this point. So I don't think that issue engages.
Yeah, but what they've said is, what she said, as I understand it, your counsel suggested, was that they don't want the old information. They want the prospective ability to get the information, assuming and when an execution is set. They want the information immediately upon the setting of the execution. They don't want the old information. I mean, at least I understood her to be saying that.
And in each of the cases involving individual defendants, they'll certainly make that ask. And the Department of Corrections
but her point is different, right? I mean, we're separating Justice 360 into like lawyers representing clients and lawyers representing a cause. To the extent we can do that, we'll just assume it for this point. But why do you say there's not a ripeness concern? Because what they're asking for is information that does not yet exist, and depending on what the South Carolina Supreme Court does, may never exist, right? I mean, they could, depending on what they say about the firing squad, there may never be information about how that is to be carried out that is certified, because it may not be a method of execution in the state of South Carolina, right? So why isn't that a ripeness concern that we're just saying, what are we doing talking about information that doesn't exist and frankly may never exist? And if it is going to exist, we don't know when it's going to exist.
Again, I think the point is there is a moment in time in which the available methods of execution are identified, certified, and at that point in time, the issues can and are joined. Prior to that, and in this context, you don't have ripeness. We have, as Your Honor points out, the very open question with regard to what are the state courts going to do in the firing squad context. That's an open question. So to ask for that information now prospectively, I do think presents the ripeness and the standing issue that we discussed and that Judge Agee began with.
So, when you're looking at standing and parts of the merits, they seem to kind of blend together, and it's hard to separate them out when you're looking at it. So if I can move to a slightly different phase of analysis from what Judge Richardson's been discussing, as I understand opposing counsel's argument, it is that assuming there's standing in the First Amendment context, once the state makes a disclosure, even under attorney-client privilege directly to the defendant, that the cat's out of the bag at that point in terms of content discrimination. That they had the option to give nothing, but once they've given something, regardless of the reason for it, then they've made an error for First Amendment purposes.
Well, they would have only made an error if they did it in a discriminatory fashion, right? And of course, they argue that they did. Now, look, as you heard conceded today and acknowledged throughout, the state could henceforth say, we're never giving you anything. We tried to be nice guys, we're never giving you anything because we're not going to go through this again. That would be a viable position for the state to take. Whether the state will take that or not, I don't know. But analytically, following Your Honor's question, The challenge that Justice 360 has here is that Houchins, United Reporting, all of those cases, and then we see in Wellens, Owens, Zink, and Sepulvado, we see the 11th, the 8th, and the 5th deal with this fact pattern. Now, in those, you've got inmates asking for the information, right? But there's no question that there's no right of access. Nobody here really disputes that. What they say is, oh, wait a second. When you agreed or offered that you'd give us some information in the context of confidentiality order, you took on a new set of burdens, and they rushed to the Fasaro case for that portion. They don't go to the first part of Fasaro that re-embraces Houchins United Reporting. They go to the second part. And they say, all right, there's a three-pronged discussion. I won't even call it an analysis in Fasaro, but there's a three-pronged discussion. Is the information closely tied to political speech that's at issue?
So it's on the edge of the envelope there.
Well, I would say it's way far away.
Tell us why Fasaro, why they don't get the benefit of Fasaro.
They don't get the benefit of Fasaro because the part of Fasaro that is applicable is the first portion, which re-embraces Houchins. But even if you go to the second portion, they don't win, and let me explain why. The first point the court considered is whether the information was closely tied to political speech. Remember, Maryland said you got to be a Maryland registered voter, which meant you had to be a resident, and you also have to use it only for electoral purposes. And the court has a long discussion about what is electoral purposes. Is that political? All right? There's nothing political here in the sense of elections or electioneering. Remember, Houchins and United Reporting deal much more similarly with this circumstance. They deal with the criminal justice system. They deal with arrestee records. They deal with jail access. They're not political in the sense of that term in an electoral context. They're very far removed from what the court
You would
described.
say Fasaro it pertains to the election of a particular candidate or an office, as opposed to, I mean, certainly, capital punishment is a political issue. So you would say Fasaro, that's not what Fasaro is. That would swallow up Houchins. What you're saying is it's got to pertain to a particular race or a particular election?
Or at least elections in general, okay? And I'll note, this is at Fasaro. The court says there are important considerations, and it goes to the three-part analysis that I described. The court describes Houchins involved access to jails. United Reporting involved records of arrestees' addresses. By contrast, I'm quoting, the list is a valuable tool for political speech. It distinguishes and says this isn't those cases because this involves an election. This involves electioneering. So they're talking about politics, not in the broad sense of politics. And if you think about it, that idea would swallow, Houchins would swallow everything. Everything's political, right? You could say, I want environmental information. I want to know where nuclear arms are stored because I have environmental concerns. You could say anything is political. But just because it's your issue of passion or choice or vocation doesn't make it political in the context of Fasaro. Fasaro clearly distinguishes there.
Your view is I understand what you've been saying, is that Fuscaro stands only for its factual predicates in that it is limited to elections and voting as opposed to other aspects of possible political speech.
I believe that's right, judges. I would point this out. It's interesting, and the court notes that and counsels into this. We have this completely clear Houchins United Reporting, no access under the First Amendment. The court, for the first time, acknowledges it's the first time an appellate court has looked at this and says, well, yes, but we're kind of concerned about something here. And they distinguish Houchins and they distinguish United Reporting. Those weren't political. So this case is different, Fusaro was, because it deals with politics, electoral process. So I think this is a very important distinction. The court waded into a place no court had ever gone. In the context we're dealing with today, we're dealing with the criminal justice system. We're dealing with the same type of thing, access to information, the government's control in the context of a criminal justice system. If I can, let me jump to the second one. They say their content, the court in Fusaro, the second part says, are there content and speaker-based conditions. In Fusaro, the content-based restriction was the electoral process. The speaker-based was you had to be a Maryland registered voter and not a Virginian. There's none of that here. You can look at the brief from Justice 360, and they'll tell you all about how onerous the confidentiality orders, that they can't consult with experts, et cetera, which is not accurate, by the way. But they don't address the questions of content and speaker-based conditions. The statute applies to everybody. No pro-death penalty person's asked for this. A pro-death penalty person that asked for the same information would have the same response. Here's the statute. So this notion that it's been selectively given to some and not to others based on viewpoint or content or the position of the speaker on an issue, it simply doesn't exist. Now, they style themselves as oppressed here and say, well, hey, we're for the death penalty and that's unpopular. And because you would have any condition, the condition can only be motivated by your desire to make it hard on me. There's no basis for that. There's no basis for that whatsoever in the record. Anybody, including a pro-death penalty advocate, would have the same issue. Important here, the statute has no content dimension to it, no speaker identification at all. And neither do the interactions of SCDC with Justice 360. Throughout the briefs, there's this idea, well, hey, you're discriminating against because we can't challenge on an Eighth Amendment basis that which you give us pursuant to a confidentiality order. And you can't, they say, talk to experts. That is...
Why won't, I take the argument to be slightly different, which is what you're discriminating against is death row inmates versus non-death row inmates, right? And so either you're a death row inmate, that is, you're a Marylander, right, under the Fusaro, or you're a non-death row inmate, that being pro-death penalty, anti-death penalty, Justice 360, whoever it is, right? That means you're a Virginian, right? Why isn't that the distinction that they're drawing, is that the only people we're giving this to are death row inmates, and that's the improper Marylanders, if you would.
2 points. First, they never make that argument, okay? So Your Honor has posited that hypothetically, but that's not made in any of the briefs. They don't say...
That's close. All right, go to the next point.
They don't say there's a speaker-based distinction here. The second point is the statute deals, obviously, in the death penalty context. In order for that argument to hold up, anything that spoke specifically to the death penalty would have to alone be out of bounds. It's not out of bounds. They're simply saying in this context, we have certain concerns. They act as if those aren't articulated. The Coley-Rushton affidavit at Joint Appendix 476 and going forward sets forth the state's concerns. Timing, movements in the process of execution. If you were going to disrupt an execution, if you were going to attempt to cut the power to a jail, if you were going to run a car into a transformer and knock it down, if you were to have a sympathetic guard internally who wanted to obstruct the process, these details of timing and movement are important. The state's basis and reasons for wanting to protect that information, to protect employees, to protect inmates, to protect the process are obvious. All right? So again, this idea that these are just made up, or somehow these are, in the language of Fusaro, are these suspect conditions. There's nothing suspect about them at all. They serve a legitimate penological process. The objective there is to say, hey, we've got to protect and safeguard the people involved and prevent disruption. Now, let me say again, I want to go back to this confidentiality order because throughout the briefing, there's this suggestion that you're gagging us. We can't go get an expert to help us figure out whether that protocol would violate the Eighth Amendment.
But it's a confidentiality agreement. There's no confidentiality order.
Well, there's two circumstances in which this come up, as I understand it. In the Sigmund case, and this is civil action number 321 CV 00278. This is a federal court case in which Judge Harwell presided. There's a consent confidentiality order that was entered. Now, throughout the briefs, there's this portrayal of you gag us, you won't let us do anything, we can't effectively represent our clients. The court, this is not in the record, but the court can take judicial notice of it. You can go to Pacer and get it. It's docket entry number 36 on April 30th, 2021.
Is Justice 360 counsel in that case? They are, okay.
They describe, they're not counsel, let me check.
I thought the discussion earlier was that Sigmund was represented by 360.
I think that's right. That's my understanding. They certainly argue that Sigmund, that the confidentiality requirements in the context of Sigmund are a basis of their injury. But again, here's the point I want to leave the court with, because it's not in the record. It's something you can judicially notice. Paragraph 5 has a protection of confidential information, general protections. It says you can use it for purposes whatsoever, no purposes whatsoever other than preparing for and conducting the litigation in which they're disclosed, and, quote, for assessing and bringing any Eighth Amendment and related challenges to defendant's method of execution. So this suggestion throughout the briefs that in the Sigmund context, they were forced to give away their ability to bring an Eighth Amendment challenge is just not true. The confidentiality order doesn't say that. Similarly, they say throughout, you wouldn't let us have experts. You wouldn't let us go talk to experts. Page 3 of the same confidentiality order says that the information can be provided to, quote, consultants, investigators, or experts, hereinafter referred to collectively as experts, employed by the parties or counsel for the parties to assist in the preparation and trial of the lawsuit and or in advising Brad Keith Sigmund on his election of execution methods and in assessing and bringing any Eighth Amendment challenge. So again, I want to knock that down. That supposed wrong isn't there.
I understand it though, Mr. Hall. Their argument is, I mean, it sort of blends back and forth, so it's hard to determine, at least for me at some points. But I think the argument that they make is broader than that. It's not just the capacity to represent the clients, which they will have under an order like that, but that it's broader political speech. We want this information in order to make a public record for influencing elections or public opinion or something of that nature.
They make that broad, generalized argument. You asked for a case, what's your best case that gives you that? And the answer was there's not one, okay? And the only case that gives them anything to work with is Fusaro, all right? Which was the first time a court anywhere had gone down this path. The first part of Fusaro says Houchins. The second part, they said, we want that second part. We want that second part. That second part is a loser for them. Is this political speech? The court in Fusaro says there's a difference between what happens in the criminal justice context and the electoral process of Fusaro. Are there content and speaker-based conditions? No. There aren't any. If you look at the briefs, you won't see any identified. And then finally, are there suspect conditions on access to the information? That's the third part of that second half of Fusaro. There's nothing suspect about wanting to preserve the safety of it. In the Fusaro case, the court ultimately said, look, there's no strict scrutiny here because the state's position is legitimate. And they said, we're going to go to a balancing test under Anderson verdict, and we're going to send that back in this situation to the trial court because they said in that context, even though the appellate court, this court, could have ruled on the record, they said the state hadn't set forth the bases to justify why it's doing what it's doing.
See if you can kind of bring this, I gave opposing counsel some extra time, and you're over too, but see if you can sum up in the next minute whatever else you want to say.
Number one, there's no standing here. Number two, Houchins, United Reporting govern. Number three, if the second half of Fusaro is relevant to the analysis, they lose because this is not political speech as Fusaro understood it. There are no content and speaker-based limitations as there were in Fusaro, and there are no suspect conditions imposed as the basis for withholding the information, having conditions on the information. Again, the Coley-Russian affidavit from the Department of Corrections sets forth why the state cares and wants to maintain the secrecy of that information for safety. So again, they've got to go all through those cases, get into Fasaro and win on that second half of Fasaro, and they can't do it.
All right, thank you very much, Mr. Hall. Ms. Ruff, you've got some rebuttal time.
Thank you.
Thank you. So I want to address a couple points made by counsel. The first is that the confidentiality agreement that he just read, we agree that the most recent agreements in Moore and Sigmund did give Justice 360 the ability to advise their clients and bring Eighth Amendment challenges.
Can I ask again, so that's as what he read from, I take it to be a consent order?
Yes,
Okay.
in Sigmund.
And in Moore, was it a consent order or was it a agreement?
It was an agreement. But that was not the initial confidentiality agreement that Appelli proposed in the Moore case. The initial agreement stated that Justice 360 couldn't use the information for any purpose, including other than facilitating its client making an election between the certified methods of execution. Justice 360 couldn't use that information to consult experts or communicate with the court.
That isn't what you ended up with?
That's not what we ended up with, but
So how is that relevant?
part of the difficulty here is Justice 360 has no idea what position the state will take moving forward. In the beginning of the argument, counsel took the position that, moving forward, it would be a viable position to argue, we'll never give you this information again. So Appelli sort of moved the ball in these various different litigations and had different rules for different inmates, and that's
Isn't that why it's not right? Right? I mean, doesn't that go back to this basic idea of like, what are we deciding here? Because we don't know if there's going to be an execution set, if it's ever set. We don't know how it's going to be set or what methods are going to be available or what positions the state is going to take. And so it just seems an awful lot like you're asking us to decide if these 7 contingencies happen, then we're going to want X.
Well, the primary relief that we're seeking is declaratory relief stating that Justice 360...
If these 7 things happen, then you get what you want. But that's what doesn't sound like right?
Well, that if an execution date is set, then Justice 360 is entitled to information about the methods of execution that will be used. Again, we expect the Owens date to be set any day now.
Not because you need it to represent the client, but because you need it to make some other political speech you wish to make.
For multiple purposes, to be able to consult experts, counsel the client, communicate with the courts, and communicate with the public. And those litigation, public
You're
education...
getting all that except to communicate with the public under these orders and agreements, aren't you?
We did get those specifically with regard to Sigmund and Moore, but again, those orders are no longer relevant given that those execution dates have been stayed. And we don't know what position Appelli will take moving forward, given that it's taken contrary positions with all the different inmates, depending what the lawyers are willing to agree to. The other points that I wanted to respond to. So first, counsel made the representation that somehow the death penalty isn't political and that in Fusaro was different because that involved an election. But in Fusaro, the plaintiff wanted access to the voter registration list to circulate a message urging the prosecutor to resign, which as the court observed was an appointed position, not an elected position. So that case didn't involve any kind of election. And in the NAA...
The voter list did, right? Wasn't the point of Fusaro that it was a voter list? Right? And voters have something to do with elections?
They recognize that a voter list is in a, quote, political context, but that specific case didn't involve an election. There was no sort of requirement that an election be at issue. And in the NAA...
Right, but what Fusaro is saying is that it's the voter list that is political, not the speech that was going to result.
The voter list was found to be political because it was in a political context. And our position is that in the NAACP and Primus cases, the Supreme Court recognized that mission-driven litigation, education, and lobbying activities aimed at protecting civil liberties from government intrusion are also political speech. So this is also a political context.
Is there anything that's not political speech? Right? If a corporation's doing it, you could be anti-big corporation, right? So if a person's doing it, you can be for or against. If that's your definition of political, then doesn't it swallow the rule?
No, because for example, in the Primus cases versus the, I believe it's pronounced Oralic case, the Supreme Court distinguished between attorneys who use mission-driven litigation to represent unpopular causes and defendants and who engage in litigation on behalf of their declared purpose from attorneys who engage in litigation primarily as a means to derive pecuniary gain and resolve private differences. And it extended certain First Amendment protections to the former but not to the latter. So the court has made this distinction between public interest versus private attorneys. And
I'm good, Judge.
Got anything else? All right, I gave counsel a little more time. Why don't you take one more minute to say whatever else you want to say?
I will just close by saying that the integrity of the capital punishment process depends on transparency in both the courtroom and the public square. And the people in whose name executions take place are entitled to reliable, balanced information about what capital punishment entails. And the judiciary, who are the last line of defense in preventing an unconstitutional execution, are entitled to the benefit of expert opinion and meaningful adversarial testing to protect against unconstitutional executions. And conversations about the death penalty should be robust, uninhibited, and wide open. Thank you.
All right, thank you very much. We appreciate the argument from both counsel. As you've gleaned from our earlier cases, we remain under COVID restrictions, so we can't come down and shake hands with counsel, so we hope we'll have that chance in the future. So before we go to our last case, we're going to take a very short recess, and then we'll be back for Ed. we're on the same page here. Ms. Bennett, we're going to hear from you first, and then Mr. Highfield and Mr. Messler will hear from you, and then we'll move to Ms. Or Mr. DeSitlin. Is that close to right?
Good enough, Your Honor.
All right, thank you very much. All right, Ms. Bennett.
May it please the court, Jennifer Bennett for the appellants. For public data to be entitled to Section 230 immunity, all three of the following must be true. First, the claims must impose liability on the company for the exercise of a publisher's traditional editorial functions. Second, public data must not be responsible, even in part, for the creation or the development of the background check reports that it sells. And finally, someone else must have asked public data to sell those background reports on its website. None of these things is true, let alone all three. And I'll start with the last one, whether someone else asked public data to post its background reports on its website. And the reason I'll start with that one is because public data doesn't...
Why do you use the word ask in that sentence instead of create? Right, because you said, did someone else ask public data to post? But the statute doesn't say ask, right?
Sure, what the statute says is provided by another information content provider. And so that is actually two requirements embedded in there. The another information content provider, that's the requirement that public data doesn't create or develop, but the provided by part also has an intent essentially requirement in there. It's not enough.
Why is that, and why, if it's got an intent, you said that they ask them to post their data. Well, I guess I'm trying to get to why you take provided by to both require intent, right? And then also that, like, not just to provide it to them, but then ask them to post it. It just seems like you're doing a lot with that word.
Sure, and it's because that's what the ordinary meaning of the phrase provided by is. So to take an example from our briefs, for example, if I were to bring cookies to this argument to share with everyone, everyone would say that I had provided those cookies. They were provided by me, even if I had bought them at Kroger's. I'm sorry?
So you're just tempting us now.
I apologize. If I had brought broccoli to this argument, everybody would say that broccoli was provided by me, even if I had bought it at Kroger's on the way here.
Better off with the cookies.
I'm sorry?
Better off with the cookies.
But wait, before you go to the
Sure.
next pages, I want to make sure I understand this part of that, though. But wouldn't that also be true if you brought the cookies and you left them in the attorney room? And so every attorney that walks in got a cookie, right? You would have provided those cookies even without knowing who was going to get them.
That's right. So it's not we're not suggesting that you have to know specifically who it is. We're suggesting that provided by means you intend to make it available. In this case, on the internet, if you leave them in the lawyer's lounge, you intended to make them available to the lawyers who are in there. So it doesn't matter that you don't know the specific lawyers in that instance, or you don't know specifically who public data's customers are. But provided by requires some responsibility, some intent to make it available to the group of people, at the very least, to whom it is being provided. And I think you can see that through, with the second half of potentially this example, which is...
But don't we have cases that interpret at least that language to mean created or developed? And on that issue, from my review of the briefs and the pleadings, it's hard. I mean, as characterized by you, there's some additional, there's additional work being done. It depends on who you do it, but how do we know whether it's been created or developed from the pleadings?
Sure. So I just want to address the first part of your question. There is no case from this court that has addressed this situation of provided by where someone went out and bought information or obtained information from someone else and put it online without being asked to do so. So this court just has never addressed that issue. But to address your created or developed.
So you would say, I want you to answer this question first, and I'll come back to it. Go ahead.
Okay. To address the created or developed, public data satisfies both of those words. It only needs to satisfy one and only in part, but we have both here. So on created, the complaint alleges at paragraph 84, which is JA 30, that public data creates the background reports it sells. And then it goes on to explain exactly how it does this. This is JA 29 through 31. It chooses what data its reports want to contain. So public data has decided we're going to sell background reports. We're going to need to create them. To create these background reports, we need to buy data. So it chooses what data that should be. It then goes out and aggregates the data it buys. It parses it. It summarizes it, including characterizing people's criminal history in ways that don't appear in these records. And then it sells the reports on its website, or rather through its website. It doesn't actually, it's not like you can go to the website and just get the reports. It transmits it to the specific person who bought it. So in all of those,
This is a different context, but in Zoran, which admittedly the world was a different place then, there's the discussion about editorial functions, because this is dealing with publications, not dealing with the provided by part.
Sure.
But you have this language about altering content. So how does that language work in with the creative and development parts from the statute, or does it?
Sure. So what Zaran or Zoran, I'm not actually sure how that person pronounced their last name. What that is talking about is taking content from other people. So in that case, it was postings on AOL that AOL's users provided, and altering it in the same way that a publisher, provided by something with an author, might edit the spelling or something like that. That is a traditional editorial function, taking third-party content and tweaking it before you put it online or in a newspaper. Here, that's quite different from deciding that you are going to create something, and to create that thing, you need to go out and use third-party content to do that. The background check reports here did not exist until public data made them. And I think here an analogy might be helpful as well, to take an offline analogy.
They're not altering content in this sense when they take this third-party information and put it in a form that might be what a publisher would do when they're taking the raw manuscript and working it up so that it will sell.
I mean, they are altering, in some extent, the data that they're buying, and they're altering it in order to create reports. So when a publisher is, say, taking a manuscript and making sure there aren't typos, that manuscript exists, it's already been created, and the publisher is making tweaks to it. Here, public data is not taking content, it's not taking something that already exists, it's creating a report, and it's using data to create that report. It's chosen to create.
Isn't that question about, don't we then have to ask about what the statute means by the word information? Because information could be just each component part of that, right? And so in any given, we might think about it in copyright terms, right? There's a work, right? And so maybe it's a different work once you rearrange the information, but it's still the information itself. And if this is analyzed on an information by information basis instead of a work by work basis, as it looks like the statute suggests, why does it matter whether they move it around or like put them together or take them apart? It's the information that matters.
Sure. So every court that has considered Section 230 has understood information in this context to mean the content that is online, not any particular bit, because taken to the extreme, any word has been used before, any fact has been used before.
Yeah, but we understand information to have something different than word, right? Like a single word by itself is not information, but, a sentence might be information.
Sure, and particularly in the context of computers and the internet, the aggregation and the organization and the summary of data has long been understood to be information separate and apart from the individual facts that organization's summary aggregation contains. And if we think about, for example, the table of contents or the table of authorities rather in our briefs, we got all of the data that's in there, all of the case names, all of the pin sites. We bought that from Westlaw, but nobody would say that Westlaw created our table of authorities. Similarly, public data goes out and buys bits of data from all sorts of places, and then it puts it all together and sells it online. And that doesn't...
The information, why don't we think about those as two pieces of information? So your table of contents has two things, right? In this particular case, is located at this page pin site in the Federal Reporter. That information, that case is located there, Westlaw did create that information, right? What you did is you created the information that site is in your brief. And to the extent the offensive part of the table of contents is that it's in your brief, you created that data. To the extent the offensive part is that it's located on this page, Westlaw created that data. Why don't we break the information apart in that way?
It's certainly, that is certainly one way to read the statute. And what I think what you're saying is essentially, why don't we read the statute to be referring to whatever information means? It means the information at issue in the claim. And so what are you alleging is illegal? And read that way, the thing that's illegal here is the reports as a whole. It's selling consumer reports without complying with the requirements of the FCRA. And the Maryland courts, the Texas DMV, the Florida DMV, the private data brokers, wherever it is that public data is buying this data, it's not illegal for any of them to have that information. What's illegal is taking it, aggregating it, and then selling it without complying with the procedures of the FCRA.
Can you talk for just a second, because you're running up, and I want to, so why, you make this argument a little bit, but I want to give you a chance to sort of address, why do we think that the FCRA depends on being a speaker at all? Right, so this is the sort of idea that at the end of the day, you know, what they're doing, as you just described, is they're selling this information. And by selling this information, that looks like being a speaker, right? And you seem to argue the contrary to that. Help me understand why they're not the speaker in that context.
So the statute says you can't. You have immunity essentially for claims that treat the defendant as the publisher or the speaker. And what this court has said in Zarin.
Well, sort of, it says that. I mean, what it says is you should not be deemed the speaker.
It says you should not be treated as a publisher or speaker. And what the way Zarin interprets that, and the way every court has interpreted that, is that liability cannot be imposed for the exercise of traditional publishing functions. And public data doesn't disagree with this. It concedes this on page 21. The question is, are you being held liable for traditional publishing functions? So taking off third-party content, putting on third-party content, or editing things that third parties want to have on your website. None of the claims here require the exercise of traditional publishing functions. They're all about public data's own conduct.
What about your fourth count? I mean, I think that argument's compelling with, you know, you don't provide the information and notice. I don't remember them all. I apologize. Sure. Various non-compliance issues with respect to the Reporting Act. But I think one you have about the accuracy of the information. Does the accuracy information, is that a weak point in the argument you're making now?
So I will certainly say that fourth claim is more difficult, but I want to clarify the fourth claim, the duty imposed by the FCRA is not that the information be accurate. The duty is that the consumer reporting agency adopt reasonable procedures. And so those reasonable procedures do not require publishing anything, not publishing anything, editing anything.
It's a procedural setting up processes that may have their goal to be accuracy. It's not a content-based claim.
That's exactly right. The duty imposed, you can sell, if you sell inaccurate consumer information, but you had reasonable procedures, you are not liable under the FCRA. And so this is in fact very similar to the HomeAway case, where it is possible. One way that public data could prevent itself from ever suffering these claims is to not publish inaccurate information. But another way is just adopt back-end procedures that have nothing to do with what actually ends up on its website, but to satisfy the procedural requirements to ensure where the data, look at where it's buying the data to match the information that's coming into it, the private request for data to dates of birth, things like that are all back-end procedures, just as in HomeAway, that have nothing to do with what actually is published.
Your argument is that, at least for the first three counts, arguably for the fourth count, public data could do exactly what it does now without any impingement on, for lack of a better word, what it publishes, what it speaks, because compliance with FCRA doesn't affect that those are extraneous.
That's exactly right. The FCRA imposes no requirements on what it publishes or what it speaks. It imposes procedural requirements that require it to, for example, provide notice to certain people to adopt certain procedures on the back end, that kind of thing.
Do we think, can you help me understand a little bit how TransUnion plays there, right? Where the court says that if you're not speaking, right, this is the standing case by Justice Kavanaugh, that where you're not speaking, you don't have a claim because you don't have Article 3 standing, right? So in other words, if your report wasn't conveyed, that's a case where they had the reports, TransUnion was sending them out with the terrorist watch list information, right? And so for the people who were spoken, so in other words, their reports were sent out, they had standing. But the people that weren't sent out, right, there was no speaking that happened, they lacked Article 3 standing. Can you help me understand, does that not suggest to us that the FCRA really depends upon the, in this case, public being a speaker?
I think there are three separate answers to that, and I want to tease them out quickly. So the first is, I think what you're saying is essentially publication is a but-for cause of the claims. Absent some sort of publication, the claims couldn't exist. But that was true in HomeAway. It was true in this court's decision in Erie. It's true in Dovey Internet Brands. And what courts have said is just because it's a but-for cause of the claims, that's not enough under Section 230. It's a publication is going to be a but-for cause of virtually any claim that occurs about conduct that occurs related to the internet. And what the question is, as this court said in Zarin, is the claim trying to hold the defendant liable for traditional publishing editorial functions? And here, that's just not the case. The FCRA isn't trying to do that.
So make your other 2 points as quickly as you can, because you're over
Sure.
and you've got a lot of other folks to hear from.
Sure. So briefly, the other 2 points is related to that. The reason publication is involved here at all is because that's the only way you can transmit data. Just as a technical matter, the only way you can transmit consumer information, the only way to sell it is technically to have a publication occur. There's no reason to believe that Section 230, when it refers to publisher, which we're supposed to interpret with its ordinary meaning, meant to include this hyper-technical requirement that just is necessary as a part of selling information. And the third thing is just to note that the traditional publishing functions are all about choosing to publish or not publish or edit content that someone else has asked you to publish. And that is not true here. Here we're talking entirely about public data's own speech, its own choice to publish. I'll save the rest of my time for rebuttal. Thank you.
All right, thank you. Mr. Highfield, on behalf of the states.
May it please the court, perhaps the most straightforward way for the court to resolve this case is to focus on one of those arguments that counsel was just making, namely that the plaintiff's claims don't treat public data as the speaker or publisher of third-party information, so Section 230C1 provides public data no protection. Instead, what the plaintiffs do is they seek to hold public data accountable for public data's own allegedly wrongful affirmative acts and omissions, things like not obtaining the required certifications before furnishing consumer reports, not informing a consumer when a report has been furnished, and not maintaining procedures designed to ensure accurate reporting. Those obligations are imposed by the FCRA on public data by virtue of public data choosing to operate as a consumer reporting agency. Those obligations don't come from the content of particular reports, and as counsel was arguing, they don't involve traditional editorial functions. So that makes this case much less like a prototypical Section 230 case like Zarin, for example, and more like Erie Insurance versus Amazon, where this court held that Section 230 did not apply even though Amazon published a product listing and even though that publication was a but-for cause of the plaintiff's injuries. Section 230 still didn't apply because the plaintiff's claims weren't trying to hold Amazon accountable as a publisher, but rather as the provider of a defective product.
So can you give me some insight into TransUnion then, right? Because TransUnion seems to suggest, it reserves in one footnote whether it really means this, but it seems to suggest that it is the speaking that causes the violation, at least for Article 3 purposes, maybe not for statutory purposes, of the FCRA. Why doesn't that undercut what you're suggesting?
So two responses, Your Honor. First, my understanding is that standing for the class plaintiffs, at least in this case, comes from potential potential harm in the future, an underspoken.
No, yeah, I get that. This is not, I don't have a standing concern, right? What I have is, TransUnion in saying this says that the injury is the publishing, right? So that's what's occurring. And if you're not published, then you have no injury. And that suggests to me that you haven't violated the FCRA. That's what I'm trying to get at.
So, Your Honor, to be clear, public data is performing a publishing function in the sense that they are providing these consumer reports. They're putting them together, they're publishing them, they're providing them. So they are functioning as a publisher. The question is whether these specific claims that the plaintiffs are making are attempting to hold them responsible for the publication functions and for the traditional editorial functions that goes into being a publisher. So we would agree that public data is publishing information, but the nature of these specific claims is holding them responsible for procedural violations of the FCRA, not for the content of a particular report.
That sounds a little bit like, you would be covered, but you're accepted because of the Fair Data or the Credit Reporting Act. And so what's your response to the argument that the statute 230 has express exceptions, but this claim isn't one of them?
So, Your Honor, we agree that there is no per se exception for FCRA claims, unlike some of the claims that Your Honor is referring to. But we wouldn't expect Congress, because of Section 230's broad reach, to specify each type of exception. So instead, we focus on the language of Section 230C1.
Don't you have to say that you don't qualify in the first place, therefore you don't need an exception? Or is that your argument?
Yes, Your Honor. Our argument is that under the plain language of Section 230C1, that protection that Section 230 offers is not available for this defendant for these particular claims. But we're not making a broader argument that there's some kind of per se exception for FCRA claims. And I'd like to call the court's attention to one other instructive case here, and that's In re Facebook, a recent decision from the Texas Supreme Court. There, the court held that the plaintiff's claims under a Texas statute that prohibits contributing to human trafficking could proceed, and that they were not barred by Section 230 because those claims sought to hold Facebook accountable not as a speaker or publisher, but for its own affirmative acts that encouraged human trafficking.
With Judge Agee's indulgence, can I ask a question? If we agreed with you on C1, don't we also have to address C2 because that's an alternative theory of immunity, using that term loosely? Am I fair in saying that? Even if we agree on C1, it doesn't apply to FCA in the context for exactly the reasons you give. We still have to turn around and deal with C2, right?
In theory, Your Honor, but here there's no claim that turns on restricting access to information or providing tools to restrict access to information. And so, yes, in theory, one would run through all of the provisions of Section 230, but none of those provisions is going to apply to public data in this context.
Good. All right, thank you very much, Mr. Heifel. Mr.
Thank you.
Metzler?
Thank you. Good afternoon, Your Honors, and may it please the Court, Jack Metzler for the Federal Trade Commission. I'd like to start by thanking the Court for allowing me to argue here today. We asked to be here to underscore that the stakes in this case go beyond these defendants and this plaintiff. The Court's decision will directly impact the government's ability to enforce the Fair Credit Reporting Act nationwide.
Can I ask you a quick question before you get started, since you paused? Don't ever pause if you want to keep going. All right, so can the FTC enforce the FCRA in the absence of any publishing? So if a company said, as a matter, we're going to engage in this credit reporting agency work, and for this class of people, we're going to do this, but this other class, we're just starting up, and we haven't actually published anybody yet. But the FTC said, well, you're still violating the rule because as a status, you're a federal credit reporting agency, You haven't sent anything out yet, but we see that you don't have the protections under, the accuracy of information. And can the FTC then bring an action in the absence of publishing?
Yes, Your Honor. And your question anticipated where I was going anyway. So
It's nice of you to say whether it's true or not.
So under the Fair Credit Reporting Act, a company becomes a consumer reporting agency when they meet the definition in the statute. And the definition is whether they are regularly engaged in the practice of gathering information about consumers in order to provide consumer reports to third parties. So it matters that they are gathering the information. That's when they become subject to the Fair Credit Reporting Act. And that's before they've necessarily provided any reports to anyone, so without having done any publishing activity. Now, some of the claims, not all of them, but some of them sort of depend on there having been, at some point, a report provided. But we argue that the claims in this case they don't depend on any publication, and for that reason, they don't treat the defendant as a publisher or speaker.
Is that, I hear you, I guess, on that, but I'm really focused on count 4, because I mean, the other 3 seem to me to be discrete enough and really unrelated to content. And I certainly understand that, count 4 is at least technically about procedures to ensure accuracy. But as a practical matter, does that ever, I mean, it's one thing to say in Erie you wouldn't have been sued for product liability but for having your website. It's another to say that applies almost to anyone on the internet. But this count 4, you're not going to be pursued for failure to have quality control procedures if the content isn't bad in the first place. Well, that's the claim that I'm struggling with, because it seems closer connected to accurate or inaccurate content than any of the other claims.
I hear you, Your Honor, but I think the conclusion that it does not involve publishing flows directly from what Congress decided to do when it when it undertook to regulate consumer reporting. It recognized that this is an important function. If you are extending credit, you are entitled to know, and it's important information to know what somebody's credit history is. But what Congress said is, if you're going to enter the business of providing this information, you have to do it responsibly. And that's why the Fair Credit Reporting Act, in that count and in the others, doesn't impose liability for false reporting. It imposes liability for not following the procedures. But to your question, your specific question, if you can imagine a consumer reporting agency that doesn't do any of this stuff, they just take whatever they find and they put it online, they provide reports, maybe it's true, maybe it's false. If we bring an action against them, it's not an element for us to show that they ever provided any false information. Now, it could be that they lucked out and everything they provided is true. It doesn't matter. They're still liable under the Act because they didn't invoke the procedures.
You would never, has that ever been prosecuted or enforced?
Well, Your Honor, it wouldn't come up. If it turned out that, I'm not saying it wouldn't come up because they would all be false. I'm saying it wouldn't come up because we wouldn't have to prove it. They would come up and say, you can't show that any of our reports are false. And we would say, well, we don't have to. That is not an element. That's not what makes you a consumer reporting agency. It's not what makes you subject to the requirements of the Fair Credit Reporting Act. And we don't have to show that to show that you violated it. Now, in practice, it often turns out that a lot of it.
Mr. Messler, you're beyond time. Is there something you want to tell us very quickly?
Well, my final point would be just to return to where I started. We hope to underscore that the stakes in this case go well beyond these plaintiffs, and that under the district court's opinion, it would severely hamper our ability to enforce the Fair Credit Reporting Act nationwide. Thank you.
All right, thank you. Tell us how you pronounce your name so we try to get this right.
Misha Saitlin for public data.
All right.
If plaintiffs prevail in this appeal, Section 230 of the CDA would not prohibit states from enacting laws that would effectively close down any website that would have the temerity to publish hard-to-find public records online in an online searchable database. Now,
If we had not a probably unrealistic hypothetical, but let's say public data for its own purposes was distrustful of the internet, and so it decided to go old school with its business, and so if you wanted to obtain the consumer reports from public data, they would only send it to you by mail or FedEx, or you'd have to drop by and pick it up. If that were the case, then you wouldn't have a 230 argument, would you?
Two things, Your Honor. One, we do not create consumer reports, not at all. All we do is have an online searchable database. We do not create any consumer reports. But with
let's assume it could be construed as a consumer report at that point.
Yes, Your Honor. Section 230 is about a free, robust, open internet. It doesn't solve all the problems of the brick and mortar world that were before the internet. So yes, we are focused on the internet. Now, Your Honor, my friend.
So if you did part of your business by internet and part of your business by U.S. mail, then you'd have a different argument for the U.S. mail part.
Right, Your Honor. Just like if Facebook started Facebook in person and then had people come and speak at Facebook forums, just like the way that, certainly some of the same speeches could be made that would be posted by folks on Facebook, but Section 230 wouldn't apply to Facebook in-person forum. But just, Your Honor, my friend for the plaintiff started with 3 reasons that she thought that we should lose, and they were: 1, this argument about is provided by a third party on purpose for a publication; 2, this argument that some of my other friends focused on about the claim by claim, and that is a regulation not on speech; and 3rd is because there are specific allegations that we in fact created this content. And I would urge Your Honors to going on any of those first 2 grounds will be truly dangerous to the internet, because if Your Honors rules on those 2 grounds, then if a website like Google Scholar creates an online searchable database, and a state imposes a vast array of regulations for them publishing that online database, then Section 230 would have nothing to say about that.
But hadn't we, in this circuit, at least already crossed the Rubicon a little bit with the Erie case? Because the Erie case says that what's important is the content of the information. Is that the subject matter of the claim? And we had a publication in that case, and because the claim was product liability in nature, what we said already is that's not about the content of what was put on the internet. And so, whether that's good or bad or damaging to the internet or not, that's Fourth Circuit precedent. So how does that not pretty much eliminate claims 1, 2, and 3, and maybe have us a robust discussion about 4?
Absolutely. I very strongly disagree. The gravamen of the claim in Erie was that defective products were sold online. The gravamen of the claim here is that we published an online database. And I would urge Your Honor to just really think about the consequences of their argument. Imagine if a state, say Virginia, passed a code of regulations that said anytime anybody tweets online, that Twitter then has to send information about that, tweets about an individual person online. Then Twitter has to send to that individual person every tweet that's ever been tweeted by them online about anything. And Twitter also has to do X, Y, and Z. Basically created a code of regulations that on Twitter for having the temerity to allow to publishing that tweet. If their argument is accepted, then Section 230 would not apply to Twitter in that circumstance. Because, of course, what they're doing here is they're saying, if you want to be a publisher, if their understanding of the FCRA is correct.
30 is about, you're not treated as a publisher with respect to information provided by another. I mean, you're talking about someone's tweets. Maybe I didn't follow your hypothetical, so I'm sorry if I missed some of that. But I mean, I don't think that. Maybe you did. Maybe that example involved hypothetically information provided by others, but it didn't seem to, or maybe I missed that.
Right, Your Honor. What I'm trying to say is that the argument that Your Honor mentioned was compelling, is truly dangerous, and could be used against Twitter, against Facebook, against AOL. This different argument that, in fact, we created the content or whatever, that's an argument that I'm happy to talk about, and I think we're right on the best reading of the complaint. But the argument that Your Honor said was compelling is truly, truly dangerous to the internet. It would be an extreme position to say that whether it's the federal government or even more dangerous to the states, that if someone publishes an online searchable database, which is all we do, we publish an online searchable database, that a state could impose any regulations it wants on the actor that publishes any bells and whistles and special onerous conditions for the right to publish an online searchable database.
Let's go back to what I understood Judge Quattlebaum's question to be, maybe incorrectly. Why is this case different from the Erie insurance case?
Because the gravamen of that case, that claim there, was that Amazon was selling a defective product on its internet, on its website, and the publication was incidental. Here, the gravamen of the claim is that we publish an online searchable database, and their incorrect understanding of the FCRA means that in order to publish an online searchable database of public records in this country, you must comply with a whole suite of onerous requirements. If that is true, then any state could enact an even more onerous suite of requirements on any company just for publishing public records in an online searchable database.
The first three counts, though, you could publish, using that word, exactly what you have now, but you'd only have to follow the Fair Credit Reporting Act for things that are not part of the publication. The content of what you put out there would not have to change.
Let me explain this, Sharon. Let's focus on the second claim, the 16.81K claim. What that claim is saying is that when we allowed people to search on our website, employers, we should have sent the consumers a notification that somebody was clicking search on our website every time. Yeah, if that is the basis of this court's ruling, then a state could enact a statute that says anytime somebody tweets about anyone, then Twitter has to send that person a notification. Somebody has tweeted about you, and they have to find that person's email, send it out to that person. That would be the exact analog to what they're saying here. And if Your Honors accepts that reasoning, says, well, look, Twitter would still allow the posting of the same tweet. They just have to find the individual person after the tweet is sent.
I don't do Twitter, so I'm at a disadvantage here, but isn't what happens there a third person puts this tweet on their platform and it goes out? I mean, it's not something that Twitter goes out and solicits or refines once it comes in, is it?
That's exactly, Your Honor. That's why I'm very strongly urging Your Honors not to rule on their favor on this argument, because it would apply to Twitter. I'm happy to talk about that argument about the third parties and whether it's changed. Now, with regard to the third...
In your example, would this apply to Twitter?
Because just focusing on the argument about the content of the tweet wouldn't change, or if Your Honor doesn't use Twitter, a message board perhaps. If the court is going to hold that as long as the publisher doesn't have to change what is actually published on their website, whether it's somebody else's message or tweet, or whether it's, a public record that's already public that we find, then that would necessarily apply regardless of how the information was obtained. So I strongly urge that if your honors are skeptical of some of our arguments, to focus on the later argument, the argument about whether we in fact created the information. Because if your honors go on that argument that we have been discussing, the implications would be...
In your example, maybe you've moved on from this, but
Yeah.
in your example, the Twitter platform didn't create that argument. It just appeared from outside somewhere else, right?
That's exactly right, Your Honor, and that then moves us away from this issue that we've been discussing here and on the other arguments in the case. Now, with regard to that, they have 2 points. One is that it was provided by a third party and not asked us to publish it. And second, that we in fact created this information. So just addressing those arguments in turn. The argument that it has to be provided to a third party that wanted us to publish it and it can't be done by an intermediary that we paid, that is contrary to the Ezra versus America Online case, which is the only appellate court to have dealt with this issue. There, America Online was sending runners out to get stock information, and the 10th Circuit held that even though AOL was sending out those runners to get that stock information obtained from third parties, that was protected by Section 230. We think that decision was correct, and it would create a circuit split.
In that case, the AOL didn't change any of the information that came from the stock sources, did they?
That's right, Your Honor. So this is very important. So if Your Honors should not go on that first major argument we were discussing, and should not go on this argument. So the
plaintiffs say you do change the information.
Your Honor, and that, in my respectful submission, that is really the only difficult issue in this case, because in their complaint they falsely allege, depending on how one reads their complaint, that we make some sort of significant alterations. In fact, and I think their complaint is...
That may be a false accusation, but at the we're not at summary judgment here, right? This is just judgment on the pleading, so we have to accept what their pleading says, right?
Right. And if this court rules that we're right on those other 2 arguments, and for the reasons we discussed, and sends back for a limited discovery on this last issue, the allegations in their complaint on that will be proven flagrantly false. All we do
Can I
is
ask this question? So I understood in part the alteration or change that was being made was not to the underlying information, but was in fact to the linking of information. So in other words, taking 5 different arrest records, right, that might have the same name, and linking them together. And the information in each record, that you're not changing, but by virtue of linking them together, that linkage was new information, right? You've now added that piece. And why is that not creating the linkage information?
Well, that's just not what we do, Your Honor. All we do is go to the courthouse, take the information, put it into a more readable format. We think that that's the best way to read the Second Amendment complaint. But if Your Honors disagree with that, read that Second Amendment amended complaint differently, send it back to lower court. It will be quickly proven up. All we are is an online search engine of hard-to-find public records. That's all we are. There are policy considerations that some of the states or the FTC might have about some other folks. All we do is go find hard-to-find public records.
My earlier question, correct, that whatever's in that complaint at this stage, we have to take as true. Correct? You agree with that?
With all reasonable inferences, that's right, Your Honor. But again, there are 3 arguments before Your Honors that my friends have fronted. 2 of them are bright line hammers, and hammers that would take a hammer to Section 230 and the internet.
So would your argument about whether the role of C1 in terms of whether you treat someone as a publisher, if someone has a contractual non-disclosure agreement and one party violates that by disclosing rather than just telling someone by an internet post, would C1 provide protection for you?
While those are not the facts of this case, the case that decided the most analogous issue to this is AccuSearch out of the 10th Circuit. And what the 10th Circuit held is that when you take private information, confidential information, and you make it public, that transforms the nature of the information. You become the content provider. What we do here is we take public records.
But that's let me just,
Yes.
my question though is, in that situation, you're being sued for breach of a contract. And the methodology that you may have breached it, rather than go into out on the street and, talking about it, or rather than writing a, letter to the editor of a newspaper, you elected to provide the information that you contractually agreed not to disclose via the internet. And is it your argument that in that situation, not counting the other issues we've talked about, like who created it or not, that you get a complete protection by 230 because you elected to violate your contract on the internet?
230 does not have any sort of bright line exception for contractual claims. It has other exceptions.
So would it provide protection?
It would not, Your Honor, because under the AccuSearch case, you're converting private information to public information, and that is creation or at least development of content. So in that circumstance,
Why would we think that's creation or development of content? I understand you've got a 10th Circuit case that says it, but that doesn't make any sense. Like, why do we? That's not creating information, right? That's just changing the forum in which it is hosted. That's what you do, right? You're taking information that's not otherwise accessible, right, that a police station has or whatever, and you're making it public.
no, everything we do is public records that citizens have the legal right to have
Ability to
access
go get. All right, that's fine. But the point is, like, I don't understand why. I mean, I'm just disagreeing with AccuSearch, I guess, but I don't understand why that would make a difference.
Your Honor, we're comfortable with AccuSearch. We think their point that the private information that is this confidential getting transformed public, that changes the information. Now, certainly there could be credible arguments to the contrary, and if that case came before Your Honors, maybe there would be could create a circuit split with AccuSearch, and they could go up to the Supreme Court or whatever. But we don't need to eat that here. Only thing that we're saying is if you have an online searchable database of already public records, and all you're doing is putting that into a nicer to read format, that's core Section 230. That is core to what the kind of free open internet that Section 230 protects.
Can I ask you a different question, just to make sure I understand? Let's assume we just hypothetically took your advice and said, yeah, maybe the complaint's close enough, and so we're going to send the C1 question back on what you actually do, right, as opposed to what they allege you do. Do we also have to address your C2 argument?
I don't believe that we made a C2 argument in this case.
That's what I'm trying to, I want to make sure I'm understanding. So you have not alleged that you have any protection under C2?
That's right, Your Honor. Now, just to be clear, they do have these two other bright line arguments, which I've been repeatedly saying are dangerous. We won on those below. So if Your Honor reversed just on is the complaint close enough issue, obviously we won on those. And the only thing that will be for the district court on remand will be to determine whether they're telling the truth in their complaint or not, which they're clearly not.
Can I go back and ask just one more? I'm sorry, they're just narrow questions, but it sort of helps me frame where we are. Like, are you a consumer reporting agency?
Absolutely not. Absolutely not, Your Honor.
Your position is that you are not.
We are a simple conduit. We do not match credit.
That question, you're not conceding that here, but for our purposes, that question would only be decided on remand, right? They've alleged that you're a consumer reporting agency, right? So don't we have to accept that for this position? I understand you're going to argue about it, but don't we have to accept that you're a consumer reporting agency?
No, that's a legal conclusion. Obviously, one doesn't have to accept it, but that's not the issue because Section 230 is an issue of immunity. We brought that defense first, but of course, their conclusory allegation that we are a consumer reporting agency is not something that can be alleged.
Just tell me briefly, if you can, why you believe that you are not a consumer reporting agency, because in many ways you seem to look like one.
Well, Your Honor, we really, really are not. Under 15 U.S.C. 1681A, you have to be in the practice of assembling or evaluating consumer credit information. That every court and FTC guidance is that you need to be evaluating and getting on specific individuals. What happens here is you go to our website, you type in, maybe if you type...
But why, I understand what you've alleged you're doing, but why isn't that assembling? Like, you're assembling it.
It has to be on specific individuals. Like if somebody goes, it's an open text search, it's an open text query. If somebody goes on our database...
That's still assembling the information, right? So you go out and buy this information, you put it in a searchable database, right? I mean, I understand that. That looks a lot like the word assembling.
The way that courts and the FTC have interpreted that phrase is that a mere conduit, putting together information that's available elsewhere and just putting it out there is not sufficient to make you a consumer reporting agency.
And what is do you have a sites and or what do you tell me to look at to have this idea that a mere conduit who assembles records is not sufficient?
Well, the cases that we cited in our brief are the Gianni versus Stern case, and I can read the site stop to you.
No, you don't need to. Just give me the name. If they're in the briefs.
Yeah, they're all in the briefs. We say we're a conduit.
And the FTC piece is also in there, their regulation or guidance.
I don't know that standing here, whether their interpretation that mere conduits are not consumer reporting.
Is that the only, and I don't want to take up all your time, but is that the argument why you're not? Is that because you're not assembling because of what you do doesn't count as assembling?
That's a correct letter. We're not assembling or evaluating information on specific individuals.
Right, I got evaluating, but assembling's the piece. But the cases you've got in the brief are the best we got to look at.
That's right, Your Honor. But of course, the court, that issue has not been fully briefed, Your Honor. Obviously, we cited those cases in our brief. But it just must be so. Because if someone creates an online open text searchable database, if someone types in, say they're considering hiring somebody named John Smith, they type that into our online search database within the Maryland courts, they're probably going to get 50, 70, 100 results for John Smith. We don't purport, like a consumer reporting agency, to tell you this is John Q. Smith that was born on such and such a date, and therefore this is his credit report. Now, if you happen to type in my name, you're probably not going to get too many other results in Maryland, hopefully no results in Maryland. So we are open text search, and if you look at footnote 37 of roommates, for example, the Ninth Circuit, in taking, I think, generally a narrower view than this court has taken to Section 230, says an open text search of a website is not development or creation, and that's really what all our website does. Now, they say that they want to read their Second Amendment complaint a different way. We think that the district court read it correctly. But again, if Your Honors rule for us on the other issues, we're quite happy to go below and prove up what we have said, that we don't...
But this question of whether you're a consumer reporting agency, I'm having a little bit of trouble figuring out whether we have to answer that question or not. Or, given the posture, don't we assume that you are, not decide, but assume that you are, and then address your 230 arguments? Or are you saying that we've got to address that as a separate? We have to either assume that there's a cause of action against you or not, right? And if you're not a consumer reporting agency, then the claims fall on the merits, not on 230 grounds.
The way that I would say it is Your Honors have to assume the hypothetical statute that they're arguing, which is that the FCRA makes it illegal for a...
Do what you do.
To create an online database of already public records that are searchable. You have to assume that the FCRA...
We don't have to decide.
Right, and I think it's very important that Your Honor say, do not decide that, because that is a very strong argument we would have, and if we unfortunately were to not prevail in this case, and we strongly hope that we do, we would certainly make that argument.
So if, for instance, we decided that we didn't agree with the majority opinion in AccuSearch, but we're more inclined to take the concurrences approach, tell us why that's wrong.
Well, as I said, we are quite happy to rely on the position that when you take private information and make it public, that is content, that is creation of content, that is changing the nature of the information. That is our position. And if your honors were to disagree with that in some other case, that wouldn't be our fight. We certainly, because you have to understand, our entire mission is to make already public records easily accessible for folks, so people don't have to go down to the courthouse. And so we certainly do not want to be advocating in court any sort of position where folks who are doing the opposite of what we're doing, taking private information, putting it out there, are somehow seeking 230 protection. Our entire business model is to make information that the people already have the right to have searchable and more easily accessible, so everyone doesn't have to do what our runners do and go into individual courthouse and search for or go on each individual court website and search for the records.
If you're able to prevail that you're not covered by the Fair Credit Reporting Act based on what y'all do, why are you so worried that we might say the nature of the claim doesn't relate to whether you're a publisher or not? I mean, it seems like you got this great argument that they're just, they're way off base with the claims they're making. That statute doesn't apply to you in the first place.
Two answers, Your Honor. One, with regard to us, Nemeth says that this is an issue of immunity and it needs to be decided up front before we have to do the burdens of discovery and things of that sort. But second, I'm advocating to the court. What Your Honors decide will set the precedent for the Fourth Circuit. And I just don't see any way out of the consequence of their position. If, in fact, Your Honors rule that you can impose a suite of onerous regulations on an online database of public records, then states can ratchet that up even more. And of course, you can tell Twitter or Facebook or AOL or any message board, if anyone posts anything on your website, all you have to do is do FCRA-like things. You got to go find the person that the tweet was about. You got to email them certain information. That is a logical, unavoidable consequence of that aspect of their argument, which is why I'm urging Your Honors not to go down that path, because that is truly dangerous to the internet. And we see the hostility towards Facebook, Twitter that's out there in the political sphere. If this kind of loaded gun can be out there, you can put any regulation on an interactive computer service you want, as long as you don't change the content of what they're posting. For the privilege of being a search engine that has online, that is online, you have to apply X, Y, Z. Then it's open season on any interactive service provider that would, in fact, have an online searchable database or anything else, I suppose.
Is it your view that to address your entitlement to immunity, that it's unnecessary to have a factual determination or a mixed question of fact and law that you are a consumer reporting agency? Because if you're not, I think as Judge Richardson's questions indicated, this goes away, correct?
That's correct, Your Honor, but as this court has held, Section 230 is a predicate immunity issue. So I think what I would say, what I said to...
We may have said that, and there's some language that certainly uses immunity terms, and a lot of courts. And I was a little surprised that your colleagues talked about that. C1 doesn't say anything about immunity. C1 doesn't say anything about no civil liability, and Congress clearly knew how to do that by the way they drafted C2. So what it really says, you won't be treated as a publisher, and we got to deal with our precedent, and maybe our precedent does, characterize that as an immunity that you look at on the front end. But, it's not what the statute says.
Your Honor, we're on binding Fourth Circuit precedent here. I don't think Nemeth could be clear on this. It was quite emphatic about this. And in fact, that, Nemeth is the broadest Section 230 decision. This court is the one that has that. There might be some other courts that take some other positions, but it is an immunity issue. It needs to be decided as a threshold matter.
You had factually developed record there that you don't have here.
I believe Nemeth was a motion, a motion to dismiss.
You had more facts than you've got in this case.
And Your Honors, if Your Honors rule against us on that third, much more narrow, fact-bound argument, and send it back, we're happy to prove up. It will be not too difficult to prove up that all we are is an online searchable database of already public records, and we will prevail on that.
Can I just ask one follow-up question to help me understand how you're thinking about this? So you distinguish Erie, and I'm less concerned about the cases. I want to understand how you're thinking about it. How do you distinguish or identify what the gravamen of a claim is, right? You've suggested that case is different because the gravamen there was selling defective products, but here it's not about your status as an agency for our purposes right now, but it's instead about your individual speech. But how do I tell that? What is the test that you think we should look at to identify what the gravamen of the particular claim is?
I mean, we don't have a full taxonomy, but here we have if their understanding of the FCRA is correct, then the FCRA is a suite of regulations that anyone that wants to publish an online searchable database needs to comply with. That is core regulation of somebody as a publisher. What happened in Erie was, it might have been but it was largely incidental. The gravamen of that claim was selling defective products. Here, the gravamen of the claim is, how dare you, public data, go find already public documents and put them into an online searchable database.
Is that good enough?
That's good. Thank you.
All right, thank you very much. We appreciate your argument. Ms. Bennett, you've got some time left in rebuttal.
Thank you, Your Honor. I just want to
If
make...
you don't mind, can you start with the question? You can take your mask off if you want to. I know we all forget. Can you start with that question, why we should think the gravamen of this case is not the publishing, where he says that what we have here, the FCRA, is a suite of regulations that anyone asking to engage in publishing must comply with. So why is he wrong?
Sure. So there are really three reasons, and I touched on these at the end. But the first reason is what Zarin says. You asked, how do you identify the gravamen of a claim that is subject to 230? And Zarin gives us that answer. Zarin says the Section 230 immunizes. Section 230 doesn't use the word immunity, but what this court's case law has said is an immunity, so I'll use that word, even though I agree with you that's a difficult way of interpreting the statute. But what Zarin says is what you have immunity for is the exercise of traditional publishing functions. And that doesn't apply here for a few reasons. One, it tells us what those functions are, and public data doesn't disagree with this. It concedes this on page 21 of its brief. Those traditional functions are deciding whether to publish, not publish, or edit third-party content. None of those apply here. So if you look at Zarin itself, it was editing or deciding to publish things that AOL users wanted to put on the internet. If you look at Nemeth, it was deciding to publish or edit things that the users of consumeraffairs.com wanted to put on the internet. So none of those, so both the function here is different. Nothing is saying you have to publish or not publish or edit something, and nobody is saying you have to publish or not publish or edit something third parties want to put on the internet or third parties want to publish in the New York Times. And the third thing I'll note is I think it's worth thinking about the type of publication that's at issue here, because I think it bolsters this idea of what 230 is really getting at. If you look at Zarin, if you look at Nemeth, what we're talking about is distribution to the public of information that people wanted to be distributed to the public. Here we're talking about publication only in the most technical, hyper-legal sense, in that you can only transmit data through a publication. They're not putting this data on their website for anybody to access. They're selling it to individual people privately. And that is a very different kind of publication, and it's what we would typically think of as a publisher. Nobody says TransUnion.
I think I understand those 3 points. I thought what you were going to come back and say is something different, and I want to just see, why isn't it, because it's the status of engaging in that business, right? That it's not you have to do these things in order to publish, but it's instead you have to do these things if you're going to engage in the business of being a consumer reporting agency. And that because that's one step removed from publishing. The gravamen is not about publishing, but is in fact the business of gathering or assembling information.
I think that's exactly right, and I think those are related points. But that's completely right. You know, the New York Times is engaged in the business of publishing. The public data is engaged in the business of selling consumer data, and that is a different function. That's the only reason the FCRA imposes liability is because it's engaged in that business. And if you look at, for example, the roommates.com case, I think is very helpful here, and it says, look, what Congress wasn't trying to do wasn't trying to shield people from the law just because they operate online. Public data admits that if they sold this data by mail, they would be subject to the FCRA. There's no reason to think that just because they're doing it online, they suddenly have immunity. The goal of Section 230 is to place the liability where it belongs, not to change what the law actually says. So here, it is public data that is compiling these background reports. It is public data that is choosing to sell them over the internet. It is not the Maryland courts or the Texas DMV. And Section 230 says, well, we put the liability where it belongs. Here, that's squarely public data. And that's true whether you look at the prong that's about treating it as a publisher. It's true whether you look at the provided by prong, and it's true whether you look at creation or development. Public data is solely responsible for the illegality here, not just materially contributes, solely responsible for what's alleged here. And I want to take a step back and make two more brief points. The first is on provided by. So public data said that the only case that deals with this is Ben Ezra. In fact, Ben Ezra doesn't deal with this, but the case that does squarely deal with this is the Batzel case from the Ninth Circuit. And that was a case where a listserv provider got an email privately that said, that accused someone of having Nazi art. And what the court said is whether you have immunity for publishing that email that you got privately depends on whether it was given to you in your role as the provider of an interactive computer service. And that makes sense based on the text and the structure of the statute. The statute doesn't say anytime you get something from third parties, you can publish it online and have immunity. What it says is if you are a user or a provider of an interactive computer service, it focuses on those roles. You should not be treated as the publisher of information, that is information on the internet provided by someone else. And so I would urge you to look at that Batzel case. I think that's very helpful here.
So you would disagree, I think based on that, you'd disagree with Judge Quattlebaum's non-disclosure argument? So you too would say that is not protected by C1 because that's private information that's turning public.
Yes, I think there are several problems with the non-disclosure agreement. There are several reasons they wouldn't get 230 immunity for that. The first is I don't think a claim based on breach of non-disclosure treats someone as a publisher. That is the Doe case, Doe v. Internet Brands. It's also the Barnes v. Yahoo case from the Ninth Circuit. The second reason is that I do think you would have at least developed the information. You have materially contributed to what makes that information illegal by disclosing it. And the third is presumably if you publish something online that is subject to a non-disclosure agreement, it was not given to you for the purpose of putting it online. So it would also violate the provided by requirement. And I just want to step back. There's a lot of talk about consequences, and I want to make very quickly 2 points on that if possible. One is to talk about the consequences of allowing people to publish anything online just because they got it from a third party. That would mean if I work in a hospital that got medical records from another doctor, I could publish them online. I obtained them from a third party. It was provided by a third party. Or if I happen to have a friend who's a New York Times reporter and I send a private email that says,
Or a Supreme Court opinion?
I apologize. Or a Supreme Court opinion. I send a Supreme Court, I'm a clerk for the Supreme Court, and I send a private email to my friend at the New York Times that says, hey, look what's happening, look what I got. And then the New York Times decides to publish it. Maybe it's fake. Maybe they know it's fake, and yet they publish it anyway. Under public data's argument, they would be immune from doing so as long as they did it online. That can't be what the law is, and that's not what 230 says. On the other hand, there are no negative consequences for saying if you choose to publish something online, you're liable for that. All of the concern about, well, states are going to overregulate information online, that's dealt with by the First Amendment. The same rules apply to what states can regulate online as offline. So I just want to make clear this case has nothing like Zarin or Nemeth or any of the cases that this court or any other court of appeals that I'm aware of has awarded Section
Do you
230
have a final
immunity.
thought for us?
Yes, Your Honor. That's the final thought, that this case is unlike any other case that I'm aware of in which a court of appeals has awarded immunity, because all of those cases are talking about immunity for claims for information that someone else chose to publish on the internet. That's not what's going on here, and for that reason, public data does not deserve immunity. Thank you.
Well, we thank counsel for their argument here. As you can see, we were not able to come down and greet counsel in person, as is our tradition, so we hope we'll have that opportunity in the future. So with that, I'll ask the clerk to adjourn us for the day.